25. This is a special docket. It will stretch to tomorrow. We have cases that we are hearing by affidavit, but we are also hearing contested cases as well. Ms. Vance, are you ready to proceed with Oxy?
I am.
Okay, let me call the first two cases on our docket. This is 25222 and 25225. We do have a special hearing examiner for this. Mr. Tony Harris, are you available, Mr. Harris?
Yes, I am.
All right, perfect. Ms. Vance? Introduce us here, please. Thank you.
Good afternoon. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Oxy USA Inc.
Good afternoon, Jackie McLean with Hardy McLean on behalf of COG and Burlington Resources.
Ms. Vance, do you know if Brad Sayer is still representing EOG?
That is my understanding. And I don't see anyone.
Do you know what EOG's position was?
Right now they've entered an appearance and they objected previously, but they have withdrawn that objection. And the parties have made some agreements, and Oxy made some adjustments to their request for relief, which I was actually going to walk through in my intro, just kind of talking about the cases and where they are. So as of right now, they just have an entry of appearance.
Okay, perfect. Thank you. Go ahead.
Thank you, Mr. Hearing Examiner. Like I said, I just was going to give a brief background where we are with the cases. So 25222 is the Bone Spring enhanced oil recovery application for Oxy, and then 25225 is the Wolfcamp enhanced oil recovery application for Oxy. These were filed in February of this year. And were previously, it was COG, Burlington, and EOG. Like I said, they had filed an entry of appearance, had objected, but have since withdrawn those objections. And that's how we've gotten out this far. And based off of those objections and the parties discussing, Oxy ended up doing some revisions to both of the applications. And those changes primarily, I'll go through them. It was the removal of wells in sections 9 and 16, removal of CO2 from the list of permissible injectants. And then there were a few slight changes to the limitations on the max rates requested for gas and water injection. And then lastly, were some changes to the operational changes in the event of a breakthrough. And so based on those changes, what we did is Oxy went ahead and prepared red lines of both applications, which were provided to the examiners just so they could see where the changes I just went over were made to the applications, that just for ease of understanding where those applications are and what the requested relief is at this point. And then we also filed last week hearing packets that included a clean version of those red lines, along with statements from our technical experts. Those technical experts are Mr. Steven Janicek, who is our petroleum engineer. And then we have Ms. Stephanie Noonan, who is our geologist. Both Mr. Janicek and Ms. Noonan have previously testified before the division, and their credentials have been accepted as a matter of record. However, we do have our landman, Miss Leslie Mullen, and then our reservoir engineer, Mr. Daniel Salamander. They have not previously testified. And so we did include a copy of their CVs with their statements that go over their educational and their experience. And all of our experts are on the line and available for questioning. Along with their statements, we did provide some additional exhibits. I won't go through those. I believe Mr. Mr. Harris has a copy of those and has probably gone through them. And then along with our hearing packets, of course, we have our notice. My self-affirmed statement of notice is included along with a sample copy of the letter notice that went out and was timely on February 21st, 2025. And then we also have our affidavit of publication that was timely published on February 26, 2025. And I will, I'm assuming Mr. Harris has questions, and like I said, we have our experts available, and we just need to make sure that we have our Miss Mullen and then Mr. Salamander, again, have not previously testified, so I would just ask that they be tendered as experts once you've had a chance to review their resumes.
Perfect. Thank you, Ms. Vance. Mr. Harris, before I continue, which of the witnesses will you have questions?
Primarily production engineering and reservoir, but if we could have it as a panel with the geologist as well, that'd be preferable.
Fantastic. That's what we'll do. All right. So first of all, Ms. Vance, we admit your exhibits into evidence without objection from any party. Let's get all of your witnesses on the screen.
I see everyone. Yeah.
Perfect. Okay, I do recognize Mr. Janacek. I'm not sure about the others. So would you please, all four of you, raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes. I do.
I do.
Okay, very good. Okay, let's start with Ms. Noonan. Ms. Noonan, would you spell your name for the record?
Stephanie, Stephanie. Noonan is Noonan.
Thank you. Have you been accepted as an expert in a field before this division?
I have.
You have. In what field?
Geology.
Okay. Now, Mr. Janacek, please spell your name.
Yes, my name is Stephen Janacek, STEPHENJANACEK.
Have you been previously qualified as an expert before this division?
Yes,
In what field?
petroleum engineering.
Petroleum engineer. Thank you. Okay, Mr. Salamander, would you spell your name?
Yes, it's Daniel Salamander, Daniel, and then Salamander, just like the animal, SALAMANDER.
And what field are you seeking to be qualified as an expert before this division?
Yes, the field of reservoir engineering.
Reservoir engineering. Okay, I'll come back to you in just a moment. And Miss Mullen.
Yes, it's Leslie Mullen, LESLIEMULLIN.
And what field are you seeking to be admitted as an expert before this division?
In the field of land.
Land. Okay, very good.
Yes.
Okay, Mr. Salamander, and Ms. Mullen, I'll ask you after Mr. Salamander is qualified by this division. But what I'd like you to do is run down your education and your experience. Give me some dates, some job duties, things like that, job titles. Let's start with your education.
Yeah, absolutely. I received my degree in a Bachelor's of Science in Petroleum Engineering from the University of Oklahoma, and that was in 2014.
What did you do after 2014?
And yeah, so after I graduated from school, I started my career actually as a drilling engineer. I worked in drilling for Anadarko Petroleum for 3 years prior to moving into reservoir engineering. I then worked as a reservoir engineer for 4 years in Colorado, working the DJ Basin, focused on unconventional resource development. And then for the past 3 years, I've been in Houston working in my current role as a reservoir engineer on the subsurface technology team here at Oxy, and again focused on unconventional resource development in the Permian Basin and mostly in New Mexico.
What is your title?
Reservoir engineer.
Okay. All right. And that's for Oxy.
That's correct.
Okay. So the division qualifies you as an expert in reservoir engineering. Thank you. And now, Ms. Mullen, in land, your education and your experience, please.
Yes, sir. I have a Bachelor of Arts, and that is in political science and elementary education. That's back from 2001, and then my MBA, I finished that in 2007. I have some non-energy, non-oil and gas, non-land experience. Higher education was one area. Before I worked in land, I have a couple of years experience with ConocoPhillips. I worked in export compliance and strategic sourcing. And then I've been working in land since 2012. I started as a land analyst working in the Texas Panhandle. That was with a different employer. That was Apache Corporation at the time. I was promoted to landman in 2014. From that period on till about 2020, I was working Oklahoma assets. And then in 2020, I moved over to work New Mexico assets. So that was large amount of land and older producing properties, and then moved to Oxy last April. My current title is Advisor Land Negotiator.
Okay, thank you very much. So you are qualified before this division in the
Great,
field of land. Thank you both for going through your resumes with me. Okay, now what we're going to do, if Ms. Vance thinks this is okay, is we're going to present the four experts as a panel for Mr. Harris to ask his question. Whoever decides to answer the question, please say your name, because we don't. The court reporter needs to know who's speaking, and then give the answer. If more than one person wants to give an answer, they can, but just one at a time, please. And then I'll give Ms. Vance a chance to redirect the witnesses after the panel is through with the questions. So, Mr. Harris, are you ready?
Good afternoon. Yes, I am.
Okay, Mr. Harris, if you would reference the exhibit first so that the witness will know, the panel will know which exhibit you're going to be questioning them about.
Sure. If we could open the case file for 25222, which is 127 pages, and it was the latest version was submitted on August 6th, I believe it was. The clean version that Mrs. Vance referred to earlier.
And I am sharing my screen, so hopefully you can see.
Very good. Yep. If we could go to page 11, please.
And let me know if you're not seeing it. Hopefully you are.
Yep, I can see it. So item 7, Roman numeral 7, and then sub-item 2 under that states that the system is closed. So I just want to confirm that all injected fluids will be sourced from within the field, or more specifically from the central tank battery. Is that correct?
This is Janacek here. Good to see you, Examiner Harris.
Good to see you.
Yes, that is correct. All of the injectant will be sourced from the Mesa Verde units.
Okay, so there's no third-party operators involved here for allocation of fluids or any of those complications. Everything is Oxy?
That is correct. Everything is Oxy.
Okay, very good. If we could go to page, I think it's page 17. Yeah, so this production profile, the third bullet point there, so it's miscible gas huff and puff has been demonstrated increased production in unconventional wells in other basins, and you're expecting an uplift here of an ultimate recovery between 10 and 30% using EOR techniques. And just wondering, what is your original reservoir pressure in this field or in this particular interval?
Yeah, this is Daniel Salamander, reservoir engineer. So for the Wolfcamp, the initial reservoir pressure is around 9,000 psi. And for the second Bone Springs, the initial reservoir pressure is around 6,200 psi.
Okay. And do you have an estimate on your current reservoir pressure for those intervals?
Yes, I do. For the second bone, give me 1 second. I'll refer back to my notes here. The current reservoir pressure in the second Bone Springs interval is around 2,000 psi, and in the Wolfcamp, it's estimated to be around 3,000 psi.
Okay. Thank you for that. If we could go to page 77, please. So just a point of clarification here, the very last bullet point at the bottom, once or after EOR injection commences, gas storage operations will not be necessary. So in that regard, so this order R22106 for closed loop gas capture. So all the wells listed in the table just above here, basically the closed loop gas capture portion of this project will be completely terminated. Is that correct?
This is Janacek. Yes, that is correct.
Okay. And just so I know and I haven't been dealt directly with closed loop gas capture applications, but I know some of our examiners that have, there's always been, a lot of issues with, or not necessarily issues, but a lot of considerations with respect to allocation. But considering the fact that Oxy is the sole operator here in this case for the miscible flood, or for the gas injection EOR flood, I'm assuming that all allocation, or that there wouldn't be any complications with allocation in this case?
That's correct. This is Janacek again. All of these wells are unitized in the unit. Either the Bone Spring or the Wolfcamp, and the interest is identical between the two. Additionally, the takeaway point for the gas that's going to be injected is upstream of our gas sales meter. So that simplifies any type of accounting issues that could arise.
Could you repeat that last part again, please, about the meter?
Yes, so the takeaway point for where the injected gas is going to be taking off of the system, that is going to be located upstream of the gas sales meter. So the gas that is going to be used for injection is not going to have passed through a gas sales meter twice.
Okay. Okay. Thank you for that. If we could move to the next page, please, 78. Just one item to clarify here. If you look at the well label as number 8 in sections 9 and 16, I believe that shouldn't be there. There's only 7 wells in this application. Is that correct?
That is correct. That should not be there. This is Janacek again.
Okay, thank you. Just wanted to clarify that. So number 8, as shown on page 78, well number 8 should not be there. It's just that the 7 wells in sections 8 and 17. Is that correct?
That is correct.
Okay, thank you. If we move to page 79, please. So again, looking at the third column here, section 17 and 8, and specifically the orange circles, those are the Bone Springs Bone Spring wells in this application. Have all these wells been fracture stimulated?
This is Daniel Salamander, reservoir engineer. That is correct.
Okay. And then if I draw your attention to the lowermost orange circle in block 17 and 8, that one's very close to the wolf camp. Does that particular well, do you think, does that communicate with the wolf camp? Is there any crossflow occurring there, or could you elaborate on your interpretation of the reservoir for that particular well?
Yes. So in that case, with the proximity to the wolf camp, there is potential for communication during gas injection. As I believe Stephen stated previously, that with the interest being the same in the two units, it should not be an issue from a accounting standpoint. But yes.
Okay, thank you for that. If we could move to page 82, please. So this is dealing with the variance requests, or one of the variance requests. So it's noted that you'll have gas lift valves installed as part of your production cycle, which makes sense, by the way, makes technical sense. Just one question here from a well integrity perspective. As you know, injection wells, every 5 years, they require a mechanical integrity test, or an MIT, as we refer to it. With these gas lift valves installed, will it be possible to perform an MIT on this wells with those gas lift mandrels in place?
This is Janacek here. I believe it will be, but I can follow up offline with our operations to make sure that's 100% true.
Okay.
My understanding, Mr. Examiner, is that yes, MITs will be possible to perform with the gas lift equipment in the hole after we set a blanking plug in the seat nipple. But I will verify all of that is accurate.
Yeah. Okay. Very good. Yeah, I guess the gas lift mandrels themselves would need to be isolated, so you'd need some sort of a side pocket mandrel to install a blanking plug into each of those gas lift mandrels in order to do an MIT or something along those lines. So we do need confirmation that an MIT would still be able to be performed on these injection well or on these wells once the EOR project commences. If we could move to page 83, please. Okay, so this talks about the very first bullet point up top. It talks about to upgrade the wellheads to 10,000 PSI components before injection commences. Can you elaborate, please, on which components would be upgraded?
This is Janacek here. Yes, I believe that's specifically talking to the tubing head components. I believe the casing heads out here are already 10K PSI, but the tubing heads, I believe, are 5K.
Okay, and the tree itself?
The tree itself, I would have to look into that.
Okay. Yeah, those are some items we would want to verify because I mean, I know these wells have been fracked. I don't know how you go about that, whether it's a tree saver or you install the tree components later. But in any event, going from a production well to now high temperature gas, we just want to make sure that all of the equipment components are adequately rated, your casing spools, your pack offs, all your valves and your Christmas tree and wellhead. So yeah, if you could share those details with us, that would be very valuable, please.
Will do.
And just while we're on the screen, so in terms of the gas lift compressor, we've got in the middle of the diagram there, it moves down, it goes through a 2-inch flow meter, totalizer. So is that the flow meter you're referring to? That's upstream?
No, this is Janacek. No, that is our well pad flow flow meter. The meter I was referring to previously was the, I guess you'd call it the master gas sales meter, where we sell gas to a third party. That is downstream of our central tank battery in those facilities.
Okay. So will you have gas injection or gas flow rate monitoring on for each well, or will it be cumulative?
Yes, it will be for each well.
Each well. Okay.
If you you can see that in the diagram on the right hand side, just below the EOR compressor. There's another flow FCV or flow control valve which will be installed for injection down the tubing.
Okay, yes, I see that. Okay, thank you. If we could go to page 85, please. So if we, at the very top portion there, I guess it's the 1, 2, 3, 4, 5, 6, under safety devices, which is the 6th bullet down. It says that the third bullet below that, the relief valves for both production and injection streams to prevent overpressure. You're saying that it says that it's not monitored by the SCADA other than for a pressure trend. So is there, how do you know, I guess, if you've had a process or if those relief valves have opened?
I believe there are other components in the SCADA system that can identify overpressures, but I can follow up on that comment and provide some clarity for you.
Okay. And then I guess I realize that currently this field is free of H2S. Is that correct, at least based on your exhibits? There's no H2S in this field currently?
That is correct.
Okay. Because we're thinking along the lines of safety here, obviously. So is there a H2S contingency plan in place for this field currently, or is that something that would be addressed later if H2S was observed?
This is Janacek. I don't know if there is I'm sure there is some type of current H2S plan for current operations for this field, and we would have something once we started injection. But I'm not aware of a plan that I've seen.
Okay. Okay, that's something we could maybe place in the order, in that if H2S is found in the future, or you start seeing signs of H2S, that the contingency plan would be required. Okay, thank you for that. If we could go to page 91, please. If we look at the third bullet down, the BLM provides approval through the annual plan of development. I guess, could you elaborate on that a little bit? I mean, has Oxy received approval from the BLM and the state land office for this particular project, or what's the status?
This is Leslie Mullen. We have not received an official approval yet on our plan of development for the Mesa Verde units. We do one for both Bone Spring and for Wolf Camp. If you see there underneath the sub-bullet, the informal meetings, we did meet with Ed Fernandez and then Balin Lamkin from the State Land Office back in April to kind of walk through our plans. We had submitted our initial applications to them and answered the initial questions that they had. This last week when we submitted our updated application and our exhibits, we forwarded that to them as well to see if they had any follow-up questions. The SLO did have a few questions just on our changes, didn't have any issues with our updated applications. But no, we have not received official approval yet on our 2025 plan of development. So we'll continue to submit the same information with our 2026 pod as well for both the Wolf Camp and the Bone Spring pods.
Okay. So once you do receive approval, could you share those with OCD for our records? Is that possible?
Yes. Yes.
Yep. Okay. Very good. One final question on that. In terms of the gas allocation, getting back to that point, I know it's different from the closed loop gas capture, but has the BLM imposed any reporting requirements for gas reporting or gas allocation in this case, or is that something that's been addressed?
Not that I'm aware of. This is Leslie. Stephen, are you aware of anything from the regulatory team?
This is Stephen Janicek. No, I'm not aware of any reporting requirements from the BLM.
Okay. Thank you. If we could go to page 101, please. Okay. If we look at the image in the upper right-hand corner, it's kind of hard to see, but it's labeled as the base of the Bone Springs. We see there's a fault which you've talked about in your application. That fault does penetrate the base of the Bone Springs and I believe the top of the Wolf Camp. Do you have any information on that fault with respect to whether or not it's transmissive or is it sealing? Do you have any information based on the production from the reservoir over the last number of years on how that fault behaves?
This is Daniel Salamander. We do have one data point. So in early 2024, based on our understanding, another operator did complete wells in that section to the south of Mesa Verde. And so I went back and looked at the production data during that time period when they were doing their completion operations. I did not see any sharp increase in produced water rates during their completion operations. And generally, those would be at a higher rate and pressure than what is proposed here for gas injection. And so that is the data point that we have, and it suggests that the fault is not communicative. And yeah, that's kind of it.
Okay. And when they were fracking in those offset wells, which zone, which interval?
I believe it's the Wolf Camp. Those were Wolf Camp wells.
Okay. Okay. Thank you. I think that's mostly it, because case 25222 and 25225, they're very similar. So the questions I had for 25222 are pretty much a mirror image for 25225. So we don't really need to go through that. I think most of all my questions have been answered. Just as a point of clarification here, in the original application, there was many more wells and you were planning for CO2 miscible flooding as well. Is there a reason why CO2 was removed? Can you elaborate on that at all?
This is Janicek here. The CO2 was removed because there were offset operators had breakthrough concerns with the CO2. So it was removed for those reasons.
Okay. So I guess do you anticipate CO2 flooding in the future at some point?
At some point when there is a CO2 source in the vicinity, yes.
Okay. Okay. Well, I guess from OCD perspective, we'd view this particular EOR case, which is fantastic, in my personal opinion. We would view this as sort of a test or a demonstration for proof of concept, and then, capture all lessons learned and incorporate CO2 flooding potentially in the future. So just wanted to add that particular point, that if CO2 flooding is planned in the future, that would require some, obviously a separate application and a more detailed investigation. I think that's it for my questions on this particular application, and I'll hand it back to our examiner.
Okay, thank you, Mr. Harris. Ms. Vance, do you feel the need to redirect, or are you done?
I don't, but I do just want to make sure that I've written down notes. It sounds like there might be a few things to follow up with Mr. Harris on once we get some clarification. And I just want to make sure that I have those down, that Mr. Janacek has those down, our experts have those down, and we're on the same page. So if we can just go over that, I'd appreciate it. Oh, Mr. Harris, you're on mute.
Sure, and I just noticed I had one more question from Mr. Salamander, if I could.
Please.
If we could go to page 113. So again, just looking at this production profile, and in your self-affirmed statement, you mentioned that there were studies performed. Was there any reservoir simulation performed here, or is it strictly analog fields that you're relying upon for your estimates of recovery?
There was reservoir simulation performed, but that reservoir simulation was calibrated with the analog field data. So yes, I mean, but this uplift is generally consistent with both the analog field data and the reservoir simulation results.
Okay, so it was calibrated to the analog fields, but was it history matched to this field before that calibration, or how was that calibration performed?
Yes, so it is history matched during the primary production that's available to us in this field. But as far as the enhanced oil recovery results, the uplift to expectations, it in order to be realistic, our understanding from analog fields needs to be considered in our enhanced oil recovery simulation.
Okay. Very good. Okay, thank you.
So, Mr. Harris, do you have a list of what you want from Ms. Vance?
I do. I've got some, I wouldn't call it a list, I got scribbles. So there's an item to clarify on the gas lift valves and whether or not an MIT a mechanical integrity test can be performed at regular intervals. And then there's also, and that's in relation to page 82 in the application. And then on page 83, the upgrade, just to clarify exactly what components are going to be upgraded on the Christmas tree, wellhead, and any valves, pack-offs, any of those sorts of casing spools, whatever the case may be. Just a listing of what components are going to be upgraded, and I guess a listing of components, the pressure rating for all components in the system that will see pressure. Then we had a discussion from page 85 about the H2S contingency plan and whether or not there was one submitted. We're not sure, and I think the takeaway point was that we would revisit that in the future. If there is an existing H2S contingency plan, that can be submitted, or you can just mention it in your response. If not, we would cross that bridge later once H2S, or if H2S is seen at a later date. And the next item was on page 91. And in relation to when the approval from the BLM and the State Land Office, once those approvals are received, if they could share a copy with OCD. And I think that was it.
Ms. Vance, anything else?
I think also, was there a question about the relief valves related to the SCADA? You had a question about that and wanted clarification.
Yes, correct. I guess, is that tied back to a closed system, or does it go to a flare stack?
I have all of those questions written down, and we will. I'm not sure if there's a timeline that you'd like to work with, but and I'm not sure how long it would take the team here to get answers to those. Mr. Janacek might be able to give a time frame. I'm not sure, but
This is Janchek here. I think we could provide all of that within 2 weeks from today.
Mr. Harris, once they provide the requested information, do you want to further review, or how do you want to proceed?
Yeah, it definitely would require some review.
Okay.
Should be very quick.
Okay, that's fine.
Quick
So, Ms.
turnaround.
Vance, if you can provide this in 2 weeks, that leaves you time for the September 11 docket hearing by affidavit. So will you continue these 2 cases to that docket, and we'll give you a deadline of the 26th, close of business?
that works for me. And just to clarify, do you want this, can we just file, do you want this filed or do you want this emailed? I'm guessing, I'm hoping we don't have to do revised hearing packets, but maybe if you do want it filed, we could just file it as a standalone supplemental document, if that works.
That's preferable, actually. The easier. Yeah, that'd be much easier. So supplemental document to be fine. Is that okay with you, Mr. Examiner?
Yes, perfect. Yes, whatever works
Okay.
for you, Mr. Harris, is fine with me.
Okay.
Okay, so Ms. Vance, again, close of business 26th August, deadline for the, please put a cover letter with this revision, or not revision, but this supplemental exhibit packet, and continue your cases to the September 11 docket. And I'm not sure that where they will be on the docket. It depends on other cases, so we'll see. All right, anything further, Ms. Vance?
Not from me. Thank you.
Any other party to this case?
Nothing.
Thank you, Ms. And Mr. Harris, anything further?
No, thank you.
All right, we're off the record in these 2 cases, and I think Ms. Bennett wanted a 5-minute recess to get herself together, and then we'll hear the Rockwood cases.
Thank you.
Thank you. Freya, do you know who our technical examiner will be for the contested cases?
I believe it's Andy.
Mr. Forsyth, are you with us?
Yes, Mr. Hearing Examiner, I'm here.
Okay, great. Can we begin?
Yes, we can begin.
All right, fantastic. All right, I'm going to call cases 3, 4, 5, and 6 on our docket. These are Rockwood Energy cases, 25243, 44, 45, and 46. This is a contested hearing. We do have competing applications filed by Coterra. Those cases are 25520, 21, 22, and 23. First, I'm going to call entries of appearance.
Good afternoon, Mr. Hearing Examiner. Caitlin Luck for Rockwood Energy LP.
Thank you, Ms. Luck.
Good afternoon, everyone. Dina Bennett from Model Sperling on behalf of Coterra Energy Operating. And with me today is Josh Hirsch, an associate in our firm.
Thank you, Ms. Bennett.
Thank you.
Mr. Examiner, Jim Bruce representing Marshall and Winston.
Good to see you, Mr. Bruce. Thank you. Let's start with you, Mr. Bruce. What is the position of your client?
Marshall and Winston supports Rockwood.
Okay. All right. Do you want to tell us why?
They just prefer their development plan. I don't know that they've signed a JOA, but they do support the development plan of Rockwood.
Okay. All right. Thank you. To be for the record, Coterra filed its 4 competing applications on a day that required them to be heard and noticed tomorrow. So we're going to begin with Rockwood Energy cases. And Ms. Luck, how many witnesses will you have for us?
Thank you, Mr. Hearing Examiner. Today, I have 3 witnesses with me. I have Tyler Jolly, he's the land witness. I also have Charlie Crosby, who is the geologist, and then Gavin Eddington, who is the engineer.
Did you say the third name?
Gavin Eddington.
Eddington. Okay. Which ones have been already qualified as experts before this division?
All of them.
All of them. Okay, perfect. That makes that easy. Do you want to make a short opening statement?
Yes, Mr. Hearing Examiner, I would like to introduce my cases and then also just do the typical rundown that most folks do before their cases start that explain the spacing unit configuration and the wall that's dedicated to each unit.
Mr. Hearing Examiner, if we could truncate this just a little bit, I'd like to give an opening statement too before Ms. Luck gets too far into the weeds. So I'm happy for her to present an opening statement, and then I'd like the opportunity to present one as well before we get into the witnesses and things like that.
Okay, and why don't we do this before we even get into opening statements? Let's see about exhibits and getting our exhibits in through stipulation. Ms. Luck, you have filed your exhibit packet?
Yes, Mr. Hearing Examiner, I filed an exhibit packet last week, and then I filed a subsequent exhibit packet, which also included some additional land, and not just land, but it included all of the affidavits. So the affidavits for the landman, the geologist, and the engineer, those were not included in the original filing. But then I also have some rebuttal exhibits I'd like to present today through our witnesses who are here to testify on behalf of those rebuttal exhibits that were put together specifically for purposes of rebutting the case of the applicant, and the other case was Coterra. This is typical in OCD proceedings, and we would like to present those rebuttal exhibits as well.
I'm just asking you to slow down a little bit because the court reporter may be having trouble catching everything you say.
Okay.
Just a little bit. Okay, so Ms. Bennett, have you had a chance to review the exhibits that Ms. Luck has filed?
I have not had a chance to review the rebuttal exhibits. Those have not been filed as far as I know. And so we have not had a chance to review those. And I would strenuously object to any rebuttal exhibits in advance of being able to see them, of course.
Okay.
But also just in terms of stipulating to exhibits, I'm Coterra's in between a bit of a rock and a hard place here. The exhibits were not timely filed. The pre-hearing order required that all exhibits be filed, including pre-filed testimony, on or before 9 a.m. on August 6th. And as Ms. Luck just indicated, the exhibits that were filed on August 6th did not include any pre-filed testimony. That testimony was not added until August 7th, so full 24 hours later. It's unclear to me why the materials were not timely filed. But, and so I intend to point that out during some of my cross-examination, but like I said, we're in a bit of a rock and a hard place here because Coterra does not want these cases dismissed on a procedural nicety like striking the exhibits. Coterra wants these cases to be decided on the merits. So I do have a lot of questions about the exhibits and about their relevance. The exhibits that are the pre-filed testimony that was filed is not filed by any Rockwood witness. There's not a single Rockwood witness who's going to be testifying today. They are Mewburn witnesses.
Okay, I understand. So let me just short circuit this.
Sure.
It sounds like you're not willing to stipulate to certain exhibits, but you will stipulate to other exhibits, or you won't stipulate to any exhibits.
At this point, I'd like to not stipulate to any.
Right.
I don't intend to strike any, but I do intend to point out some reliability, relevance, and credibility issues.
And if I may respond, Mr. Hearing Examiner, I would like to respond to both points that she makes. In this case, Coterra has been given incredible leeway in terms of late filing their applications. And I think likewise in this circumstance, this is a 2-day hearing. It's always been scheduled to be a 2-day hearing between August 12th and 13th. There was never any set provisional time for when Rockwood's cases would be heard. And the exhibits were filed well in advance of a week of August 13th, which is tomorrow. And I would ask that if there's any issues with so-called late filing of those exhibits, that the division examiner consider the fact that Coterra has also been given incredible leeway in these proceedings. They appeared when the cases were originally set in April, May, July, and no applications were ever filed during that timeframe. There were 6 months that lapsed before their applications were filed. And Rockwood has permitted them to come with us to a contested hearing today, Mr. Examiner. And so for that reason, we would ask that the late filed affidavits be admitted, as well as these rebuttal exhibits we put together to rebut the evidence that Coterra would like to use to attack Rockwood's cases. And then with regards to the second point related to the Rockwood witnesses, today with us here, we're lucky to have Mr. Bruce. And Mr. Bruce has been in the oil and gas industry for a long time. Just like I've had many hearings over here at the OCD. There is a wide range of contract professionals that are allowed to testify as experts in these proceedings. Like I mentioned previously, all of my witnesses have been qualified as expert witnesses. There is no issue with their credentials related to their expert testimony. What Ms. Bennett is raising is a contractual issue, which is inadmissible with regards to their admissibility as an expert in these proceedings. I think Mr. Bruce would support the fact that many different types of contract professionals testify for operators in the oil and gas industry, and the terms or nature of their testimony is never reliant on who their employer is.
Okay, I understand, Ms. Love. Okay. The question, the sole question that I'm dealing with right now is Coterra willing to stipulate to Rockwood's exhibits? The answer is no. So that doesn't mean that they won't come in. It just means that you're going to have to provide a foundation. There is an issue about the pre-hearing order. The pre-hearing order was issued in May. Is there, I think,
and Mr.
Well, let me just finish, Ms. Locke, before you go on with whatever you want to say. Do you have a copy of the hearing order?
Yes, Mr. Hearing Examiner, and Coterra's applications did not comply with the hearing order. So I just want to be clear about that we did end up going back and amending the pre-hearing order to allow their late filing of the applications, but I've got a copy of the pre-hearing order here. Okay,
so let me put one thing to rest here. The idea of late filing. Ms. Bennett's 4 applications were filed 20 days before tomorrow. I know that Mr. Bruce was drawing a point to today's hearing and that it was 19 days, but they were noticed for tomorrow. They're not late. They comply with the rule. So Ms. Luck, that argument doesn't really do anything for me right now. I realize that they came late in the whole 6-month scenario since February, but they do comply with the rule. So let's talk about the pre-hearing order for a moment. You have a copy pulled up, right?
Yes, Mr. Hearing Examiner.
What does it say about the pre-hearing statement and exhibits? When do they need to be filed?
It says 4 days in advance of this hearing by 9 a.m. that morning, Mr. Hearing Examiner. And so I did read this and I reviewed it with Ms. Bennett.
Yes.
And I also mentioned that just like her applications were allowed to be heard tomorrow, that provision of Rockwood's cases could be continued until tomorrow to cure any issues with respect to the 9 a.m. prior to the hearing, because tomorrow the hearing does once again commence at 9 a.m.
Okay, was there a reason why? So you filed something on one day and then something else on another day. What was the first day you filed?
The first day was our complete set of exhibits. We had all of our exhibits in there with the exclusion of our testimony
What day was that?
on August 6th.
And how many business days is that before today?
Yes, sir. I understand that that is 4 days before the hearing today, but our hearing today was both delayed and continued throughout the proceedings tomorrow.
Okay, so the 6th was timely. All I'm trying to say is that the 6th was timely.
Yes, and I believe that the 7th is also timely because the 7th is once again 4 business days before from tomorrow. Yes.
Yes, I got that point 3 times now. Once is enough for me. Okay, so please don't keep repeating yourself over and over again. I get it the first time. I'm listening to what you're saying. And I'm trying to give you consideration as I would give Ms. Bennett.
And I would like to point out, though, that Ms.
I'm not
Bennett.
finished speaking, Ms. Luck. Why are you interrupting? Okay, thank you, Ms. Luck. Okay, so we have exhibits filed on the 6th, and then we have more exhibits filed on the 7th, which will be timely for tomorrow. Okay. All right, Ms. Bennett, that satisfies me as to the timeliness aspect of the exhibits. This is a 2-day hearing. Yes, it starts today. If this were a 1-day hearing, the 7th would be late. Now the rule, do you have a copy of the rule, Ms. Luck? Okay, can you turn your microphone on? Okay. Under the rule,
And if you'd like, I can read you the rule.
I have the rule in front of me. I'm reading from 1915-413 and back. The pre-hearing statement has to be filed at least 4 business days before a scheduled hearing. Was the pre-hearing statement filed timely, Ms. Luck?
Yes, Mr. Hearing Examiner. And once again, if I can read the entire rule, it says at least 4 business days in advance of a scheduled hearing before the division or the commission, but in no event later than 5 p.m. on the Thursday preceding the scheduled hearing date, which would make this timely.
Okay, all right. Okay, so we've talked about the timeliness of the exhibits. So Ms. Bennett, if there is an objection to the exhibits, I'm overruling it. So we're going to hear this on the merits as you want to anyway. All right. So Ms. Luck, a quick opening statement, please.
Well, and again, Mr. Hearing Examiner, I'd like to run through the typical intro opening statement that we give in polling cases, which includes introducing the cases, introducing the lands involved, the subject acreage, and the initial dedicated well. That's typically how I have presented polling cases before this division. I would also like to include that information as well as my brief opening statement.
I'll give you 5 minutes, so go ahead.
Thank you, Mr. Hearing Examiner. Thank you to the examiner who is participating in this hearing today. Rockwood Energy is asking for its cases in case numbers 25243 through 25246 to be granted because Rockwood filed its applications first in this case. The applications were filed on February 26th of 2025, which was approximately 5 months in advance of Coterra's applications. Rockwood has letters of support from all of the other interest owners in the units. There's 9 total letters of support. Coterra is the only party that Rockwood's seeking to pool in this case. So it's very important that we understand that there's no question that Rockwood has engaged in voluntary, contractual, good faith negotiations with Coterra regarding the subject acreage, and any reason or discussion that Coterra wants to bring up at this hearing regarding the negotiations is inadmissible under the rules related to pre-hearing negotiations. And so I would ask that any of those negotiations be left out of this hearing under 11408. In this case, it's also undisputed that Coterra has engaged with both Mewburn and Rockwood related to these units. That's never been a confusing issue for Coterra. Coterra has always known Mewburn as a top-end operator in the industry, an experienced operator in the industry, and knows how to operate oil and gas wells for a long time. So Mewburn is ready, willing, and able to drill these wells immediately as proposed by Rockwood.
Did you say Mewburn?
Yes.
What's the relationship between Mewburn and Rockwood?
And if I may continue my opening statement, any questions related to this could be directed to our witnesses.
But I'm asking you.
And I'm an attorney in this proceeding, and I'm not allowed to introduce my statements with regards to what the evidence is in this case, but I'd like to introduce my witnesses regarding the evidence.
Okay, Ms. Luck, I'm not asking for evidence. You brought up a point just now. You said Mewburn is going to be operating these wells. And my only question to you is, what is the relationship? Is there some sort of contractual relationship between Rockwood and Mewburn? Why have you brought up the name Mewburn at all?
Because it's also going to be discussed extensively by Coterra throughout these proceedings about what Mewburn's involvement is in this unit. And not just this unit, all 4 of these cases. So Mewburn and Coterra have had negotiations, just like Coterra and Rockwood have had negotiations related to these units due to Mewburn's contractual interest.
Okay.
So Coterra's applications are a reflection of Coterra's unpreparedness through all stages of this process. Hearing testimony and evidence will show that Coterra isn't ready, willing, or able to drill these wells. Coterra hasn't completed the title work in the unit and should not be the operator chosen at this hearing. As to the first factor related to the competing pooling factors, Rockwood clearly has the ability to efficiently recover the hydrocarbons, and there are less risks associated with Rockwood's proposal. As stated, Rockwood engaged in extensive negotiations prior to the hearing, and Coterra is the one who has failed to engage appropriately and timely with all interest owners, as shown by the letters of support from all other 9 interest owners in these units. Rockwood has the ability to prudently operate and prevent waste. And most importantly, Rockwood is able to drill these wells before the lease expirations, which happens July 2026. And so in these contested cases, if Coterra is not prepared to drill the wells by April 1st of 2026, Rockwood is asking that the orders default back to Rockwood if Coterra is granted the application so that these wells can be drilled before the lease expirations. And that's an issue that we're going to bring up throughout all of these proceedings, that there are pending lease expirations, which are happening in about 8 months. And so since the lease expirations are, it might be closer to 9, but the issue here is that we need to be sure that the pooling order is issued and the wells are drilled before the lease expirations. I think that we've already addressed the issues related to the contract professionals that are going to be testifying today, but I would continue to like to bring up the fact that the scenario that's going on today between the relationship between Rockwood and Mewburn is happening in countless other cases before the division. For example, Mr. Hearing Examiner, I was involved in case 25164 before the division where COG applied, but it was really Admiral that would be operating the wells. And I can go through the division's case list and pull countless other examples where there is a contract operator who is engaged by the operator applying for pooling to be sure that the wells are drilled timely. And because of the situation with Coterra in these cases, Rockwood had to engage in a contract operator. And then once again, if there's any confusion related to the contract negotiations, I would request that the hearing examiner keep those contract negotiations out related to 11408, because that rule says under the rules of evidence that any pre-hearing settlement negotiations are not admissible evidence. Turning now to the cases at hand, I just want to overview each case. Case number 25243, Rockwood is seeking an order pulling all uncommitted mineral interests in the Bone Spring Formation. This is designated as an oil pool, and it's underlying a 400 acre, more or less, spacing unit comprised of the west half of sections 25 and 36.
Ms. Luck, the 5 minutes is up, and we have read the applications carefully, so.
And I'm sorry, but my 5 minutes were interrupted by some questioning, so I would like to finish up the summary of each of the applications because this is typical in all polling cases.
Okay, but you don't need to. This is a contested hearing. It's not a hearing by affidavit. You're going to have lots of witnesses, lots of testimony. We don't need to go through the typical opening. We've all read the applications.
But for purposes of preserving our record in this case, I think it's extremely important to state what Rockwood's seeking in its applications and then give Coterra the chance to present their cases accordingly.
Mr. Fordyce, are you familiar with what Rockwood is seeking in these 4 cases?
Mr. Hearing Examiner, yes, I've reviewed their exhibits that were filed, received by OCD August 7th.
Okay, thank you.
I'm not familiar with any rebuttal exhibits that were mentioned. I've reviewed the exhibit packet filed August 7th.
Okay, thank you. Ms. Luck, let's go to your rebuttal exhibit, what you mentioned before. When did you file those?
I have not placed this on file with the OCD because I was going to ask Ms. Bennett's permission to do so, given our issues with the earlier filings. I wasn't sure the appropriate process. I thought that I could bring those up at the hearing today, but if it's not appropriate, I will not do so.
I'm not telling you what's appropriate and what's not appropriate. So all I'm saying is I tried to get your exhibits admitted through stipulation. They have not been, so you'll need to provide a foundation to each exhibit as you go through your witness testimony. Ms. Bennett, 5 minutes to you for an opening statement.
And Mr. Hearing Examiner, if I may, I'd like to finish my opening statement because my opening statement was interrupted by questioning.
Okay, so no, you're not allowed to speak any longer in your opening statement. Thank you, Ms. Luck. Ms. Bennett?
Thank you, Mr. Examiner. As I've said from the start of these cases at every status conference, this has been and continues to be a moving target, and today's hearing proves my point. In February, it was a Rockwood case. In April, Coterra was supposed to negotiate with Mewburn. In May, it was Rockwood again. In June, it was Rockwood. Or sorry, it was Mewburn. Now in July, who knows who it was, Mewburn or Rockwood, we don't know. But here today, it's a Rockwood application with Mewburn witnesses. That's confusing. That's a moving target. Rockwood's exhibits, as I mentioned, suffer from serious legal and factual deficiencies. And I'll get to that, but before I do, I don't want to lose sight of the fact that no matter what, even if those deficiencies were cured, Coterra wins at the end of the day here because Coterra has the majority working interest any way you slice it. So, and it's undisputed that Coterra has the majority working interest. So Coterra has the majority working interest in the Rockwood units. Coterra has the majority working interest unit in working interest ownership in its units. And when you compare the Sombrero, which are the Coterra cases, with the Shepherd cases, which are the Rockwood cases, Coterra has the majority interest, even as compared against Rockwood's own ownership. So at the end of the day, there's a lot that can be said about the different negotiations, and I don't agree about 11408, but I'll save that for another time. At the end of the day, the fact of the matter is Coterra has majority interest ownership, and the division and the commission have held that in the absence of any other compelling factors, majority interest ownership is the controlling factor. And there are no other compelling factors that weigh in favor of Rockwood here. Rockwood has never drilled a well in New Mexico, not one. Rockwood is relying only on Mewburn as a contract operator, but there's nothing in the exhibits today that identify the relationship between Mewburn and Rockwood. So there's no evidence in the materials that Rockwood submitted that shows that Mewburn has the right to testify on Rockwood's behalf. Contrary to Ms. Luck's statement, it is not usual practice for other operators to testify on behalf of a different operator. I'm certainly aware of contract geologists, contract reservoir engineers testifying on behalf of someone who doesn't have a reservoir engineer or doesn't have a geologist, but never have I seen an operator like Mewburn testify on behalf of another operator. And in fact, in the cases that I'm aware of, and that coincidentally Ms. Luck was involved in a recent case, which was Alpha Energy, Alpha actually refiled its applications and said that, and identified the contract operator. And in fact, there's a spot on the compulsory pooling checklist that says applicant, designated operator. So the division is, there's no prohibition against having a contract operator, and there's no prohibition about having contract geologists or reservoir engineers testify. What's happening here, though, is there's no authority shown for Mewburn to testify, and there's nothing in Rockwood's applications that demonstrate that Rockwood is going to have a contract operator. That's a material deficiency under the division's material deficiency policy. And so those are some of the legal infirmities that I intend to get into with the Mewburn, not Rockwood witnesses. But I don't want the division or any party here to lose sight of the fact that at the end of the day, this is very shut and dry. I'm sorry, open and shut. Coterra has the majority working interest. Coterra should be awarded operatorship under the division's factors.
Okay.
Thank you.
Thank you, Ms. Okay, let's get your three witnesses on the screen, Ms. Luck.
Okay, I have Tyler Jolly, Tyler Jolly, Charlie Crosby, and Gavin Eddington.
Thank you.
And if I may, I'd like to respond to some of the statements that Ms. Bennett just made once again about the contract operations.
It's not evidence. We're not doing argument here. Opening statements are opening statements, and that's all they are. There's supposed to be a roadmap to what the evidence is going to show us. That's all they're supposed to be.
And
not really
my opening statement was truncated, so I have a few more statements I'd like to make in response to Ms. Bennett.
Ms. Luck, I'm sorry. We don't have time for that right now. Let's get your witnesses sworn in. Let's let them do the hearing. Okay, please all three raise your right hands. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, I heard two yeses. I didn't hear a third yes.
Yes.
Thank you, Mr. Jolly. Would you spell your name, Mr. Jolly?
Yes, Tyler, Tyler, Jolly, Jolly.
And Ms. Luck advises me that you've been previously qualified as an expert before this division?
Yes, sir.
Excellent. In what field?
Land.
Thank you, sir. Okay, next, please. The next witness, spell their name, please.
Charles Crosby, Charles Crosby.
And you've been previously qualified before this division as an expert?
Yes, sir.
In what field, please?
Geology.
Geology, thank you. And the last witness, please?
Gavin Eddington, spelled GavinEdington.
Thank you. And the same question to you?
Yes,
Yes, what?
I have been an expert witness before.
Before this division?
And petroleum engineering.
Petroleum engineering, did you say?
Yes.
All right, thank you. Ms. Luck, who do you want to call first?
I'd like to call Mr. Jolly as my first witness.
Okay, Mr. Jolly. You're under oath. Go right ahead, Ms. Luck.
Okay, thank you, Mr. Jolly. I believe you already stated your name for the record, but could you also state by whom you're employed and in what capacity?
Yes, I'm a landman for Mewburn Oil Company.
And have you previously testified before the division and had your credentials accepted as a landman?
I have.
And are you familiar with the applications filed by Rockwood in case number 25243 through 25246?
I am.
Okay, and are you familiar with the status of the lands in the subject area?
Yes, ma'am.
Okay, and based on that information, I would move to admit him as an expert in land to testify in this case regarding the exhibits that were also submitted with his exhibit packet.
Okay. Ms. Luck, all of your witnesses have been previously qualified, and there's no objection to the fact that they are experts, so you don't have to qualify them. Now, what did you say about exhibits?
Okay, well, sorry, sir, I would need to turn to my exhibit C1.
Okay, now where will I look to see that? I'd like to see that myself.
I apologize. Would you like me to share my screen?
I don't think you need to, unless Mr. Fordyce wants you to share your screen. I'm going to look at your exhibits on the imaging system. Mr. Fordyce?
No need to share your screen. I have the exhibits pulled up as well.
Okay, so Ms. Luck, let's first direct me to an exhibit number.
Yes, Mr. Hearing Examiner. So first we'll be turning to exhibit C1.
Okay, and this is for all, is the exhibit packet going to be the same for all four cases?
Yes, Mr. Hearing
Okay,
Examiner.
perfect. All right, let me get your exhibit packet opened up. Hold on one second. I want to be able to follow along. I see. Okay, I see this is the document filed on the 7th at 6:47 a.m. And I see exhibit C1, you said?
Yes, Mr. Hearing
Okay,
Examiner.
right ahead.
Page 35 on the PDF.
I'm there. Thank you.
Okay, so this, Mr. Jolly, could you turn to exhibit C1? Do you have it?
Sorry, Caitlin, which one is C1? I have a hard copy here.
Oh, that's okay. The C1 are the C102s.
Okay, the C102s. Okay,
Yeah, so,
I've got them right here, sorry.
okay. And so looking at Exhibit C1, can you explain to us what those documents are?
Yes, these are C102s outlining the wells that Rockwood applied to drill and complete, targeting the Bone Spring Formation, servicing in Section 25 of 1835, and then their bottom hole location ending up in Section 1 of 19 South 35 East. But this shows where the wells will surface, the dedicated acres, the targeted formation, and the well name.
Okay, thanks. And so turning to Exhibit C2, if we may, or do I need to move admission by each exhibit?
We need to go exhibit by exhibit. So did you ask this witness if he prepared this himself?
Mr. Dolly, did you, I can ask him that now, Mr. Hearing Examiner, sorry. I can ask him that now, Mr. Hearing Examiner, if you'd like.
Yes. We're going to have to provide a foundation, pretend that this is like criminal law now, and you have to provide a foundation to show me that this is a reliable document, and you want to ask your witness, who prepared the document? Has he reviewed it? Does he adopt it under oath? Go through the steps for us.
Okay. So Mr. Dolly, turning back to the C102s, is this a full and complete C102 form?
Yes.
Has it been signed?
Yes.
And at this point in time, do you have anything else that needs to be changed or added to this form?
No, we reviewed these C102s before they were submitted.
Okay, so this document was either prepared or compiled under your direction or supervision?
Yes.
Okay, and so with that, I would move the admission of Exhibit C1.
Yeah, I'm not sure I heard the question. You went a little fast, Ms. Luck. So let me just ask the witness myself this question. Mr. Jolly, did you prepare these C102s?
They were prepared under our supervision.
What does that mean?
Well, Rockwood signed the C102s, but we certainly provided guidance before they were submitted.
Okay, so when you say we, do you mean you?
Mewburn Oil Company.
Oh, okay. I'm just trying to find out what you mean. Miss Bennett, your take?
May I ask a few follow-up
Please.
questions?
Yeah, why do you're the witness? Yeah.
Thank you. Thank you for being here, Mr. Jolly. I appreciate it and nice to see you. A moment ago, you said that these are a full and complete C102. Do you recall that?
Yes, ma'am.
Don't C102s have 2 pages each?
Most do, yes. Yes, ma'am.
And isn't the second page usually a drawing, a plat map?
Yes, ma'am. Usually they are.
So this is not a full and complete C102, is it?
It looks like this is the C102 that Rockwood submitted.
Where do you see that Rockwood submitted this C102?
I don't see it anywhere on the page that says that Rockwood submitted the C102. Is that usually on the C102?
Well, she can't answer your question, Mr. Jolly.
So a moment ago, you testified that this C102 was prepared under your supervision. And by
Yes,
your, I mean Mewburn's, not necessarily your direct supervision. When did Mewburn become involved in Rockwood's development plan?
And I'm going to object to this question because I'm not sure that it's relevant to the foundation, like laying this document. Excuse me. It's not relevant to laying the foundation for the admission of this document into evidence.
Well, I see it differently, Ms. Luck, so I override your objection and I'll explain to you why. Your witness here has testified to certain things about this document that now put this document's reliability into jeopardy. So at this point, it's looking like I'm not going to admit this C102 unless we find out some different facts about the C-102 and your witness's involvement. He didn't prepare this document. It's not a complete document. So you can argue all you want, but I overrule the objection. Please continue voir diring. And would you please answer the question, Mr. Jolly?
Yes, ma'am, or yes, sir. Can you please repeat the question?
Certainly. When did Mewburn become involved in the Rockwood Shepherd development plans?
Early in 2026, or I'm sorry, early in 2025. I don't recall the exact date.
So you don't recall the exact date. Is there anyone who can testify about the exact date?
I don't recall the exact date. No, ma'am.
And thank you for that. But is there any one of the Rockwood witnesses who are Mewburn witnesses actually who can testify as to the date?
I don't think so.
This C-102 was issued or was signed on February 17th, 2025. Do you see that at the bottom?
Yes, ma'am.
So sitting here right now, you can't say for sure that Mewburn was involved in this prospect before February 17th, 2025, can you?
We had been in contact with Rockwood about these lands before February 17th of 2025.
But were
So I don't
you,
know the exact date that we were involved.
so you're saying that even though you can't remember when you became involved, that you somehow know that at least by February 17th, 2025, things were being prepared under your supervision?
I guess I don't recall the exact date that Mewburn and Rockwood. No, I guess I don't know the exact date. No, ma'am.
Thanks. On this exhibit, it has an O-grid number. Do you see that? 341867?
Yes, ma'am.
Do you know if that is an OCD O-grid number?
I assume that it is. That's not Mewburn's O-grid number, but I assume that's Rockwood Energy's correct O-grid number.
Is there anyone here who can testify whether that is Rockwood Energy's correct O-grid number?
I'd have to defer to another one of the witnesses from Mewburn.
And would it surprise you to learn that that is not Rockwood Energy's correct OCD O-grid number?
I did not know that was not the correct O-grid number.
If you look down towards the middle of the C-102, it says spacing unit type, and then it has horizontal and vertical. Is this a C-102 for a vertical spacing unit?
It should be for a horizontal unit.
Mr. Jolly, if you had reviewed this, would you have agreed that this is a vertical spacing unit?
Like I said, it should be a horizontal spacing unit. If it was incorrectly reviewed, then we can definitely look at that.
And if Mewburn had prepared a C-102, would it have your O-grid number on it, the correct O-grid number?
If Mewburn prepared a C-102 for a well that Mewburn was going to submit with Mewburn as operator, then it would have Mewburn's O-grid number on it.
On this C-102, who does it say is going to be the operator?
Rockwood Energy.
Is Rockwood Energy going to be the operator of these wells if Rockwood is awarded, if its applications are granted?
If Rockwood Energy is awarded operatorship and a pooling order to go save their interest on expiring leases, their plan is to transfer the pooling order to Mewburn Oil Company, and Mewburn Oil Company is ready to go perform and save their leases.
And you think that going to a contested hearing is the fastest way to save those leases? I'm striking my question.
And
I strike my
Mr.
question.
Examiner, if I may step in here regarding these C-102s, it's commonplace in these OCD hearings for draft C-102 forms to be submitted. In the case that Ms. Bennett referenced earlier, the Hollywood Star cases, there were draft C-102s presented in that case. I didn't object on behalf of my client at that point in time. Those C-102s also had a plethora of errors. These are not filed C-102s, they are drafts. And I want to clarify any misstatements related to that. We're happy to submit revised exhibits with the correct information. related to the well development plans. That's typical and common in these draft C-102 forms for there to be errors, and they can be rectified throughout this process. I've worked on many cases. I was here last week, and many revised exhibits were filed at that point in time during the regular hearing.
Okay, Ms. Luck. Ms. Luck, the problem here is that this witness didn't prepare these documents, the C-102s. His review seemed to have missed some major problems with these. They're supposed to be 2-page documents. They're 1-page documents. So these exhibits won't be admitted. Now, you can file new C-102s. I'll give you until the close of business. I'll give you until the hearing is over tomorrow to file new C-102s, and this witness can prepare them, and this witness can testify and adopt them under oath. But I won't accept these. These will not come into evidence.
And I want to be clear, it's very common in these proceedings for the C-102s to be prepared by someone else other than the testifying witness. Countless cases, the C-102s are not signed by the witness who testifies. And I would ask that that not be the case in this scenario either. That should not be required by the division for the C-102 to be signed by the witness who is testifying. The provision regarding expert testimony is whether or not the exhibits are compiled under their direction or supervision. This is an inappropriate misstatement of the rules by Ms. Bennett that these C-102 should be stricken, where these are draft documents. And in many cases, draft documents are submitted and then revised.
Okay.
Mr. Hearing.
I'm not arguing, hold on, Ms. Bennett.
Thanks.
I'm not arguing, Ms. Luck, that it's never the case that someone else prepare a document and then that the expert review that document and adopt that under oath. I have no problem with that. The problem is there's so many problems with these C-102s that they're not reliable. And I won't let in unreliable evidence into the hearing record. That's my job. I'm the gatekeeper for evidence. So these won't come in. If you want to try again and make a new argument, that's fine. We'll take a look at them. We'll have your witness testify to them. We'll hear objection or not, and then I'll make a ruling, but these won't be coming in. So do you want to move on now?
Okay, I just want to clarify the OCD's exhibit revision policy, because I attended the hearing last week on August 7th, and in countless cases of polling before the division, everyone was allowed to present revised exhibits. And I want to be sure whether or not that's going to be permissible in this case.
I've already said that to you, Slut. That's what I'm allowing you to do.
Okay.
But these documents won't be, these exhibits won't be coming in. Were you going to say something, Ms. Bennett?
Yes, thank you. And I do want to clarify that it's not my position that Mr. Jolly needed to prepare the C-102, but rather that it be prepared under his supervision.
Agreed.
I agree with Ms. Luck that there's oftentimes a team that prepares the hearing exhibits. And it's unusual, at least in my view, that a company other than the company that prepared the C-102 would be testifying on
And
behalf
again,
of the
I would like to
C-102.
respond to that, because Ms. Bennett has had countless cases where this exact situation was going on before the division, where there would be a contract operator who would be engaged after the pulling order is entered. That is the same scenario that is happening here. It's very commonplace throughout the oil and gas industry. And Ms. Bennett has been involved in many of these cases. I can give you some of the examples. First of them is 25164.
I'm not asking for examples of stuff, thank you. So I've made a ruling on these exhibits. These are not coming into the record. You have an opportunity to submit new C-102s. And so why don't you continue your case?
Okay, when am I going to have the chance to recall my witnesses to ensure the admission of Mr. Jolly's exhibits?
Until the end of the hearing tomorrow.
Okay, so my witnesses will be recalled at the end of Ms. Bennett's case?
It's up to you to recall your witnesses. That's your job. So you have that opportunity.
Okay, Mr. Jolly, turning to exhibit number 2, which is page 39 in the exhibit packet, can you tell us what exhibit 2 shows?
Exhibit C2.
Yes.
This is a section plat showing the spacing unit of the proposed Shepherd 25-1 Statecom 521H well. The spacing unit is going to cover the west half of section 25, the west half of section 36 and 18 south 35 east, and then the west half northwest quarter of section 1 of 19 south 35 east.
Okay, and this relates specifically to the Shepherd 521H well in 25243.
Yes, ma'am.
Okay, and does this also provide a unit recapitulation for the 521H well as highlighting the interest owner to be pulled?
Yes, ma'am.
Okay, and then continuing on through C2 on page 42, there's a section plat for 523H. Can you explain to us what that shows?
Yeah, similar to the plat for the 521H. It shows the spacing unit of the well, the surface location, the bottom hole location. The 521H is cut short because there's already a well that another operator drilled through the west half southwest of section 1. So that's why the 521H is shorter in length than the 523H and some of the other wells that were proposed.
Okay, and moving on down through the exhibit, that also shows the recapitulation of the unit ownership interest and the party to be pulled, which is Coterra. Is that correct?
Yes, ma'am.
Okay, so then on page 45 of the exhibits, can you tell us what that section plot shows for the 526H well?
Yes, the section plat for the Shepherd 25-1 State Com number 526H is a well also servicing in section 25, going through section 36 of 18 South 35 East, and then also traversing section 1 of 19 South 35 East.
Okay, and this portion of the exhibit then goes on to show the recap for the unit and the tract ownership in the unit, and the only party to be pulled is once again Coterra. Is that correct?
Yes, ma'am.
Okay, and then the final couple of pages, starting on page 48 of C2, that is a section plat for 528H. Can you explain to us what that page shows?
Yes, it's also a section plat for the Shepherd 25-1 State Com number 528H. Shows the service hole location in the northeast of section 25. It's a 3-mile lateral cutting through the east half of section 25, the east half of section 36 of 18 South 35 East, and then also traversing through the east half of section 1, 19 South 35 East.
Okay, and the final pages of Exhibit C2 show the recap of the unit and the only party to be pulled again, which is Coterra. Is that correct?
Yes, ma'am.
Okay, and so with that, I would move the admission of Exhibit C2.
Ms. Bennett,
Thank you. If I may ask the witness some questions.
go ahead.
Thank you. Mr. Jolly, did you prepare exhibits C2?
Yes, ma'am.
Were those prepared from Mewburn's title or from Rockwood's title?
These were prepared from county records done by both Rockwood and Mewburn.
Does Rockwood have a landman that you consulted with to prepare these exhibits?
I do believe there's a landman that works with Rockwood, yes.
Did you consult with that landman to prepare these exhibits? And by these exhibits, I mean exhibit C2 only.
Yes, we consulted with Rockwood about the exhibit C2, yes.
Did you personally consult with the landman?
Yes.
What's the landman's name?
Kelton Powell is the representative at Rockwood that we have been in communication with.
Is there a reason why Mr. Powell or Mr. Kelton, I'm sorry, what was his name? Kelton Powell?
Yes, ma'am.
He's not testifying today though, is he?
No, ma'am.
On these exhibits that you prepared, it doesn't show Marshall and Winston as having any working interest ownership, does it?
No, ma'am. They're not being pooled.
No, I understand they're not being pooled, but you don't show them as having working interest in these unit recaps, do you?
We only showed Coterra as they're the party being pooled.
I understand that, but I'm asking you whether you show Winston and Marshall as owning a working interest in these tracks.
We do.
Where?
I believe Marshall and Winston owns throughout section 36. I believe when they made their assignment to Franklin Mountain, they reserved a piece. They also own in Tract 3, which is VC 891, which I believe is the lease that's expiring next year.
Thanks. I don't see that anywhere in your exhibits, and I'm not trying to make a huge deal out of this. I just was wondering if you knew that the division has been asking Mewburn specifically to include committed and uncommitted working interest owners in their unit recaps?
We can provide updated ownership if need be, but the other owners aren't being pooled.
I understand that, but the division has specifically required Mewburn in prior cases to submit unit recaps that can that include both committed and uncommitted, and this does not do that. Is that right?
This only shows Rockwood and Coterra. We only showed Coterra because they were being pooled, but we can update the exhibits if need be. The other parties aren't being pooled.
I understand that. I'll leave it to the division to decide whether the tract maps need to be updated, but I will say that in prior Mewburn cases, the division has required Mewburn to submit revised exhibit packets that show uncommitted and committed working interest owners.
And again, Mr. Hearing Examiner, there's no rule related to that. This is just all conjecture. This is an argument being made by counsel that this is a requirement. This has never been required in other pooling cases. There's no rule that's being cited to, so I'd ask that that be denied.
Well, I'm only here to deal right now with the admission of Exhibit C2. So, Ms. Bennett, you voir dire the witness. Do you maintain an objection, or you didn't object at all to it? Are you objecting or not?
No, I'm not objecting to this exhibit, but I do reserve the right to ask further cross-examination questions, not limited to voir dire.
Okay, C2, Ms. Luck is admitted. C1 is not admitted. And I want to be very clear. You have until tomorrow, whenever the hearing ends, and I don't know what time the hearing will end, but you have until that time to submit new C102s and have a witness testify to their accuracy here at the hearing. Is that clear?
Yes, Mr. Hearing Examiner.
Excellent. You want to go on to C3 now?
Yes, if the examiner is ready.
Go right ahead.
So turning to Exhibit C3, which is at page 51 in the exhibit packet, Mr. Jolly, can you explain what that is?
Yes, this is a sample well proposal letter that Rockwood sent out in February of 2025, proposing the wells. Also behind that is, it looks like their AFE showing the cost to drill and complete the wells. And all this was sent out in February of 2025.
Okay, and also towards the bottom, I think, of those exhibits, let me just check.
What page were you on?
Sorry, I just want to be sure. Yeah, we went all the way through those. So 50 all the way through 55, that ends those exhibits. So with that, I would move the admission of Exhibit C3.
So what I would like you to ask the witness for each exhibit, Ms. Luck, is do they adopt this exhibit under oath? I'm trying to establish some sort of accuracy, some sort of reliability. And if all he says is it looks like it's this, it doesn't leave me feeling very confident, especially after the C102 incident. So please ask your witness if he adopts them under oath.
And I would just like to clarify, in these OCD proceedings, there's a lot of errors that happen. And I attended the hearing on August 7th. And again, I'd note that each of the cases, they were permitted to file revised exhibits. And so I don't know why there's a big issue being made out of some errors on the documents in these cases that can be rectified and clarified before the hearing ends in this proceeding. And I'd just like some courtesy regarding that, because it seems like there's some confusion in these cases, that there are some issues that may happen throughout the form completion process. And we'd like to proceed with the hearing in a manner that's professional.
I would too, Ms. Luck. So thank you for saying that, and hopefully we can do that together. The problem with these exhibits, Ms. Luck, is that they were not prepared by this witness. This witness has been qualified as an expert, so he's qualified to review all of the exhibits and then make a expert opinion based on them, but he needs to adopt them under oath if you want to get them in If there are errors, I'm sure Ms. Bennett is going to point them out. And it really just depends on how many errors there are and how fatal those errors are to the document's reliability that I have to make a judgment of. So would you please ask your witness if he is going to adopt this exhibit under oath?
Mr. Jolly, I want to clarify, are you adopting Exhibit C3 under oath as being compiled or prepared under your direction or supervision?
Yes, ma'am.
Ms. Bennett, are there any objections to C3?
I'd like to ask a couple of questions. Mr. Jolly, this letter was sent out on February 12th, 2025. Do you see that?
Yes, ma'am.
And did you review the proposal letter before it was sent out?
Yes, ma'am.
And so you recall that you reviewed this particular proposal letter before it was sent on February 12th, 2025?
Yes, we were in communication with Rockwood when they were proposing the wells.
Turning to, so the letter was sent out on February 12th, 2025. Do you know when Rockwood filed its, well, I'll ask you that on cross-examination. Turning to exhibit the AFE at the end. That's on page 55. Do you see that?
Yes, are you referring to the AFE for the Shepherd 25-1 State Com number 521H?
Yes. That's the only AFE that made it into the exhibit packet. It looks like there should be AFEs for the other wells, right?
Yes, ma'am, and we can provide those. I apologize about that.
Thank you. Those are I don't object to this document being admitted into evidence with the addition of the AFEs, but I do reserve questions for cross-examination.
Okay, so I can't admit a document with the condition that additional documents are also added. So either you object to this document by itself, or I can admit this document and it stands for what it stands for.
That's fine.
If there's missing other AFEs, then it's up to Ms. Luck to provide them, to help strengthen her case. But I can't admit this conditionally like that.
I understand. No objection to the admission of this exhibit.
Ms. Luck, C3 is admitted.
Thank you, Mr. Hearing Examiner. Turning to Exhibit C4, which is found at page 56 of the PDF. Mr. Jolly, could you tell us what this document shows?
Yes, this is the communication with Coterra Energy Operating Summary of Communication starting in January of 2025, all the way through July 2025 with Coterra Energy Operating Company.
Okay, and included on pages 57, 58, and 59 are summaries for each of the 4 cases. Is that correct?
Yes, ma'am.
Okay, and was Exhibit C4 prepared or compiled under your direction or supervision?
Yes, ma'am.
Okay, and with that, I'd move the admission of Exhibit C4.
Ms. Luck, you didn't ask the witness if he adopts this exhibit under oath.
Okay, sir, and I'm sorry, Mr. Hearing Examiner, is there a rule or some type of judicial procedure that requires that being asked for each witness?
There is, and I'm going to insist on Ms. Bennett asking the same question to her. And if you object to her exhibits, see, she has objected to your exhibits. So you have to show me that they're reliable. So if you'll ask the question, please.
And Mr. Jolly, do you accept this testimony under oath?
Yes, ma'am.
Ms. Bennett, any objection to this to C4?
I would like to ask the witness a couple of questions.
All right, and Ms. Bennett, you don't have to ask me that you would like to ask a question. Just say, I want to voir dire this witness and go ahead.
Thank you. Mr. Jolly, did you participate directly? So, sorry, this is a summary of communications between Rockwood and Coterra, is that right?
Yes, ma'am.
Were you involved in any of these communications directly, you, Mr. Tyler Jolly?
We have been in communication with Coterra about these lands and these proposals and the situation between Rockwood and Coterra, yes.
I don't want to belabor this, but were you a CC on the 1/24/2025 email?
And I'm sorry, I'm not sure what Ms. Bennett's referring to.
Is this an objection, Ms. Luck?
Yes, I'm sorry, I'm not sure what she's referring to, a 1/24/25 email.
Okay. But if the witness knows what she's talking about, then the witness can answer. If the witness doesn't know, he can say he doesn't know.
Okay, but how does this have to do with Exhibit C?
So is this an objection, Ms. Luck?
Yes, Mr. Hearing Examiner. Relevance, what does this line of
Okay,
questioning
fine.
have
That's
to
all
do
you
with
have to
Exhibit
say.
C4?
Just give me an objection timely and tell me what the basis is so I can deal with it.
Okay, and I'm sorry, Mr. Hearing Examiner, in previous cases that I've been involved in, the technical rules of evidence didn't apply like in a courtroom where we're able to just have back and forth discussions. And so I just want to be clear. I'll defer to Ms. Bennett. I didn't mean to interrupt her questioning, but I just want to be sure. I wasn't sure what the email was that she was referring to.
Okay, so Ms. Bennett, the objection is to relevance to the question.
Thank you, Mr. Examiner. The 1/24/2025 email is the first email listed on the summary of contacts in Exhibit C4. And what I am trying to elicit from the witness is whether he or anyone from Mewburn participated in any of these discussions.
I understand what the question was, Ms. Bennett. The objection is to relevance.
Yes.
How is it relevant?
It goes to reliability, Mr. Hearing Examiner, and it goes to the foundation of this exhibit. If Mr. Jolly did not participate in any of these communications, I'm not necessarily going to ask that it be stricken. I'm just going to be asked that it be accorded the weight it's due, given that it's a summary of contacts that he had no personal involvement in, if that ends up being the case at the end of my discussions with him.
And I would just like to respond to that because in countless cases, there are land managers involved and other land broker professionals involved in running the title work and corresponding with the parties initially, where when the landman testifies, they're taking a compilation of information and putting it together for the OCD hearing. This is not all based on firsthand testimony, firsthand experience, that this is not lay witness testimony. This is expert testimony compiled from a compilation of other professionals and based on Mr. Jolly's experience as a landman in the profession, what's admissible at these proceedings.
And so, Ms. Luck, I don't disagree with anything you've just said, but that doesn't mean that this is an irrelevant question. Ms. Bennett seems to be going in the direction of how familiar are you, this witness? How familiar is this witness with this document? And that seems to be where she's going with it. So I'm giving her wide latitude to do this. She hasn't objected to the document yet, so there has been no objection. If she objects, then I'll allow that sort of argument to come in and I'll weigh what's going on here. But it's relevant.
But see, what Ms. Bennett's getting at is the fact that Coterra is so-called confused. They have a first-time landman on this project and he's claiming confusion because there were multiple parties involved in the contract negotiations. And so what she's trying to get at is that Coterra is confused and at some point Mewburn stepped in and so that confused Coterra. But this is Coterra's landman's first time on in an MOCD case. Maybe he doesn't really know how contract negotiations go. And so I don't think that it's clear here that Mr. Jolly did not have to be involved in each and every one of these correspondences or communications back and forth with Coterra. Coterra has at all times known about Mewburn's involvement. And Ms. Bennett brought this up during her opening statement. And so that's why we have to bring this full circle.
She did. That was argument that she made. You're correct. However, Ms. Bennett is trying to get to the reliability of this document, and I'm allowing her to question the witness to understand his basis, his involvement with this document. And that's what she's asking. That I'm not taking it into what the scope you are.
Right, but I think that her question is whether or not he was CC'd on a January 24th, 2025 email.
Yes.
And that is not required. There is no requirement that an email be sent or received by the party testifying.
But Ms. Luck, it's a question that goes to his familiarity with the email.
Okay, and this is a summary of all communications. It's not just with the content of a simple email that's mentioned in the summary of correspondence. So I'll defer to Ms. Bennett in terms of what she would like to argue here. But the issue here, though, that Coterra is raising is that they're confused by Mewburn's involvement.
Okay, thank you, Ms. Luck. Ms. Bennett, so please, the objection is overruled. So would you ask a question again? Because I'm not even sure what the question was.
Yes, thank you. Mr. Jolly, looking at this list of communications, were you or Mewburn involved in a direct communication between yourself and Rockwood and Coterra on any of these dates?
Can you
And by
repeat the
yourself?
question? I'm sorry.
Sure. And I really don't want to belabor this, but I think if I point to one email, it might be easier to just go through it one by one. I don't want to, but let's just look at the first notation, January 24th, 2025. It says email with a representative of the above listed party. Were you or anyone at Mewburn involved in that email to Coterra?
And again, I want to object because that's not required for this document to be admitted.
Overruled.
This summary of communications was prepared in coordination with Rockwood. I don't know that I was copied on the specific email on January 24th, 2025.
And can you identify a specific email or call or meeting on this list that you or someone from Mewburn participated in?
A lot of the communication between Mewburn and Coterra and Rockwood has been done over phone calls. I don't know that I was copied on a specific email, but the emails were sent in conjunction between Mewburn and Rockwood. So I don't know which emails I was specifically copied on. They were done in coordination with Rockwood.
Have you reviewed all of the emails that are the basis for this summary?
Yes, ma'am.
Was Mr. Kelton Powell involved in the email communication?
I'm sure he was. Yes, ma'am.
Is there a reason why Mr. Powell isn't testifying today?
Ms. Bennett, you're just adhering this witness to his involvement in C4. I'd rather you keep your questions to just.
Thank you. I don't object to the admission of this exhibit.
Ms. Luck, C4 is admitted.
Thank you, Mr. Hearing Examiner. And at the end of C4, we also included, starting on page 60 of the packet, some letters of support that we believe correspond with the summary of communication. Sorry, the first one is a little bit blurry, but then these, that would conclude the exhibits that I had filed on August 7th. We also received 3 additional letters of support. And so that's why they were received late this week, and early this week, and I would like to present those now to the division, ask Mr. Jolly about these 3 additional letters of support and move to admit them as Exhibit C5 as additional letters of support for Rockwood's pooling case.
Right. Is this, I can't find, I see where you labeled all your other exhibits, but I don't see a C5 anywhere. Is it somewhere I missed?
No, Mr. Hearing Examiner, and this is the issue that we covered at the beginning of the hearing, that I did not file the rebuttal exhibits. I'm not sure if I was supposed to file them before or go over them with Ms. Bennett here at the hearing today, but Exhibit C5 is only on my computer at this point in time because I thought that I was going to have to be reviewing the exhibit with Ms. Bennett on the record and determine whether or not she would agree to the admission today.
Yeah, hold on a second. But you do have these letters of support in your filing. Are they labeled as exhibits?
No, those were included with Exhibit C4 originally, but then we received more letters of support, which I would like to add as C5. So there was these original letters of support that start on page 60. So there's 60, 61, 62, 63, 64.
I see.
And then we received 3 more letters of support, which I would like to present as
You're
C5.
saying that these letters of support are part of C4?
Yes, Mr. Hearing Examiner, because they were part of the basically like summary of correspondence related to the negotiations that we engaged with all the parties that were involved in this unit, because these are other interest owners in the
A
unit.
simple yes would be fine. Miss Bennett, are you objecting to the letter? I wasn't sure that C4 was included the letters. Did you understand that?
I understood that yesterday, but today I forgot. But I don't have any objections. I'd like to ask the witness some questions on cross-examination. In terms of the new letters, though, that Ms. Luck is seeking to add to the record, I have not seen those.
Okay, well, we're just talking about what's here in the record right now. So we have, are you going to clarify this blurry one for for when you refile this? Are you going to clarify?
Yes, I'm sorry, I can refile that document. I didn't realize it was going to be uploaded that way.
Oh, okay. So we have a letter from Charles Morgan. We have other letters here to Spencer Sale. Okay, so these are all admitted into evidence, Ms. Luck. Is there anything further? Is there any further direct testimony that you want from Mr. Jolly before I turn it over to Ms. Bennett for cross-examination?
I would like to present those 3 additional letters of support as Exhibit C5 before the division today and determine if Ms. Bennett would object to them or if I could send them to her by email and once again file them.
We can deal with that part tomorrow. Right now, we have these letters of support. So no, not right now, Ms. Luck. They're not here in front of us, so no. If you wanted them admitted, you should have filed them timely. So are you finished with the direct examination from this witness?
Yes, and I just want to clarify, some of these letters were received after the filing of the exhibit, so we could not file them before the filing deadline on August 6th. One of them is dated August 11th.
Okay,
So-
we'll find out more about the other letters tomorrow when you seek to admit them into evidence. But I do have a question for you because I'm on page number 67. Can you go to page 67 for me? Whose exhibit is this? The one right after the last letter in the packet.
Oh, well, sorry. I think that the letters actually ended on 64 and then Mr. Crosby's affidavit started on 65.
Ah, okay.
Apologies. I misstated the numbers.
Okay, there we go. Okay, I understand. Thank you, Ms. Luck. Okay, are you finished with, can Ms. Bennett cross-examine this witness?
Yes, thank you, Herr Examiner.
All right, thank you. Ms. Bennett?
Thank you. I'm trying to share my screen, so if you'll give me just a second to share.
While you're doing that, Mr. Bruce? Mr. Bruce, is your microphone on?
Yes, sir.
Okay, I haven't heard from you at all during this whole exchange. Does your client own an interest in all of the lands here or just some of the tracts? I can't tell.
As far as I know, just some of the tracks. I don't. My involvement is only over the last few days.
Oh, I see.
And so I don't have a really good idea of
Okay.
Marshall and Winston's land holdings out here.
Would you be able to send an email to your clients and ask them?
I will do so.
All right, thank you, Mr. Bruce. And Mr. Bruce, you didn't, I'm assuming you don't object to any of the exhibits.
I do not object to it.
I didn't think so. Okay, thank you. All right, Ms. Bennett?
Thank you. Thanks again, Mr. Jolly, for being here. Earlier today, you testified that you're employed by Mewburn. Is that right?
Yes, ma'am.
And so you're not employed by Rockwood, is that correct?
No, ma'am.
Do you have a contract with Rockwood?
Yes, we have a contract with Rockwood. Should they receive a pooling order to drill the wells and protect their interests, Mewburn would step in and be operator.
So Mewburn doesn't have any working interest ownership in these units?
If Rockwood receives an order, so they can be operator, we have a contract where Mewburn would have working interest if Rockwood were to become operator of the unit.
At the moment, though, Mewburn does not have a working interest ownership in these units?
No, ma'am.
And you know that Rockwood's applications seek to have Rockwood named as operator, right?
Yes, ma'am. They would become operator under the order, and then they would transfer the order to Mewburn.
And again, there's no Rockwood witnesses here, though, to testify that that's the deal with Mewburn.
And again, I want to object to this line of questioning because I think Ms. Bennett has hit this point home that there are no Rockwood witnesses. Mr. Jolly has advised as to the contract terms that Mewburn's interest is currently and what his status is as a testifying representative.
Thank you, Mr. Examiner. The point I'm trying to make here is whether there is anyone from Rockwood who can confirm Mr. Jolly's
I
testimony.
think the answer is no, Ms.
Okay, thank you. How long have you been employed by Mewburn, Mr. Jolly?
And again,
I
I'm going to
started
object to
July.
that. Sorry, I think that Mr. Jolly has been admitted as an expert. I'm not sure if that should have been covered back in the beginning when he was being qualified as an expert, but I think that he is qualified as a landman in this proceeding. So I don't know if his education experience really go to this testimony.
That overruled. Go ahead, answer the question, please.
I started at Mewburn Oil Company July 1st of 2015.
And in the 10 years that you've been employed by Mewburn, have you ever testified on behalf of another operator?
And again, I'm going to object because I think this is irrelevant to these proceedings. This is very commonplace throughout the industry, and Ms. Bennett is getting into a line of questioning that does not relate to these cases.
Ms. Bennett?
Thank you. This goes to reliability and credibility, Mr. Hearing Examiner. If in fact, first of all, I disagree. This is not that common of a practice to have one operator testify on behalf of another operator. As I mentioned, I don't disagree that there are often contract geologists and contract reservoir engineers. What I'm trying to get to the bottom of here is whether it's a Mewburn case or a Rockwood case that we're really dealing with here. And so I just am trying to understand if Mr.
And Ms. Bennett, why would that matter?
Because the applications are Rockwood applications.
Okay.
And they seek to have Rockwood named as operator.
If I may respond.
No, thank you, Ms. Luck. You've already made your objection. I've heard the response. So Ms. Bennett, I'm going to give you a very short leash on this line of questioning, okay?
Thank you. In the 10 years that you've been employed by Mewburn, have you ever testified on behalf of another operator?
No, ma'am.
Did you prepare your self-affirmed statement?
Yes, ma'am.
Okay, so I'm going to turn to that now. It's Exhibit C, and I'm on page 30. Do you see that? I have it up on the screen.
Yeah, let me turn to it. Okay.
On the first line, you see that I have it highlighted. I have personal knowledge of the matter addressed herein and am competent to provide the self-affirmed statement. Do you see that?
Yes, ma'am.
In your normal practice as a landman for Mewburn, do you normally identify that you are employed by Mewburn in your affidavits?
I'm sorry, repeat the question again.
In your practice, your normal practice as a landman for Mewburn, do you normally identify that you work for Mewburn in your declaration?
And again, I'm going to object to this because I don't know that it's necessarily relevant to this case at hand. Mewburn has not applied to be the operator in this case. Mewburn is not the applicant that prepared this polling application. Mr. Jolly has been qualified as an expert in this proceeding. His employment with Mewburn and his experience in other cases is not exactly on point to what's going on in this case.
Ms. Bennett?
Thank you. The reason I'm asking these questions is because the declarations they lead to further confusion by what they leave out. There is confusion in these cases. If Mr. Jolly had simply mentioned that he works for Mewburn, that would have alerted everyone to the fact that he works for Mewburn, and we would not be spending time on this. So my point is that there's a lack of information in the self-affirmed statements that adds to the confusion that both the division and Coterra are faced with at the moment.
So Ms. Luck, the division has to decide how much weight to give Mr. Jolly's testimony as an expert. And to judge that, if there are omissions of fact, then we need to know about what they are. It doesn't automatically discredit the affidavit. So I'm not saying that, but these questions are relevant to the weight we want to give this affidavit and this expert testimony. So Ms. Bennett, please keep your questions short and to the point.
I will, thank you. Mr. Jolly, I have up on the screen an order that the division has entered. Do you see the screen? And I've highlighted some text.
I'm not sure what this order is being presented for. It hasn't been provided to me prior to this hearing. Ms. Bennett is simply sharing her screen. There's been no provision of this to me prior to this hearing, and I would just object to any further questioning.
Okay, Ms. Bennett.
Thank you. This is an order that was entered in an OCD division case, and it sets out the 7 factors that the division considers when adjudicating competing applications. And I was merely going to use this as a demonstrative to show what the 7 factors are, but I'm happy to just walk through those without showing them as a demonstrative.
And why is that relevant to this witness?
Mr. Jolly's testimony is designed to, at least it should be designed to demonstrate to the division why Rockwood should be granted operatorship of this. And the division evaluates 7 factors when analyzing competing applications. And so Mr. Jolly's testimony should address these 7 factors.
But the fact that it does or doesn't that, I mean, I'm not understanding why this is relevant to this witness's testimony. Does it not just stand on its own for the division to consider and give its weight it deems necessary?
Definitely. I wasn't trying to admit this as an exhibit. I was
Right.
just using it as an illustrative showing of the factors so that I don't have to restate them.
And
But
that's
I'm
fine.
totally,
Demonstrative exhibits are just fine. And now Ms. Luck knows why you're using this, but why, in the bigger picture,
right.
why do you want to go down? Why are you trying to go down this route?
Because as the applicant, or I guess the applicant's agent, Mewburn has the obligation of demonstrating the factors have been met in Rockwood's favor. And so what my plan was to walk through the factors and ask Mr. Jolly what portions of his testimony address the factors to show in fact that Rockwood has not met its burden. Those are the factors that outline the applicant's burden.
Okay, and that's fine to the points in the 7 factors that this witness testimony
Yes.
would lay on. Let's not go to all 7 because I don't think his testimony goes to all 7. So please restrict your questions just to the ones.
And if I may respond, the factors they are not included in any rule where there is a statement that these factors need to be included in an affidavit. Ms. Bennett is making a claim that our affidavits are missing something or there's material omissions. And I think rather than presenting the law back to the division that the division should know, Ms. Bennett should be pointing out what she alleges is missing from our case.
Okay. And I agree with that. And that's just what I just said a moment ago. So I already agree with that, Ms. Lau. Thank you. Ms. Bennett?
Thank you. And again, I'm just using this as shorthand for what is the applicant's burden. And so, Mr. Jolly, your testimony addresses ownership, right, which is factor F on this list?
Yes.
And it shows that Coterra owns the majority interest in the Rockwood spacing units, right?
Yes, I don't think anyone's disputing that.
And is it your understanding, well, I'm not going to ask that. With respect to prudent operations and the surface factor, which are factors D and G, a comparison of the ability of each party to prudently operate and a comparison of the ability of applicants to timely locate well sites on the surface. Your testimony doesn't address Rockwood's surface facilities, does it?
Their surface facilities, I guess I'd have to defer to our engineering witness on that.
But does your testimony address that?
And I just want to be clear, nowhere do these factors say that they're supposed to be involved in the testimony. It says that these are the factors the commission may consider in evaluating competing pooling applications.
Ms. Luck, a moment, and I'm not sure what the objection is, but Ms. Luck, a moment ago, you said that it's Ms. Bennett's job to show which of these factors is basically weak in your case, and that's what she's doing. So I'm not sure what you're saying anymore. Go ahead, Mr. Jolly. Would you answer the question, please?
Can you repeat the question, please? I'm sorry.
Certainly. Is there anything in your testimony that addresses Rockwood's surface facilities?
The C-102 and shows, I believe, the surface hole location. I'm not sure about the facilities. Like I said, I'd have to defer. I guess my testimony does not. If we want to go into surface facilities, I think our engineering witness can testify to that.
Thank you. How about third-party takeaways? Does your testimony doesn't address that, does it?
My testimony does not contemplate takeaway, but Mewburn, I believe, is as an operator, has drilled the most wells in this area. So I would think that we probably
you.
have a plan for takeaway.
Thank you, but your testimony doesn't address it, is that right?
It does not, but like I
Thank
said,
you.
Mewburn has drilled the most wells in the area, and I think that we could probably figure out a way for takeaway.
Does your testimony doesn't address any discussions with the state land office, does it?
I'm sorry, can you repeat the question? I apologize.
Your testimony does not address any discussions with the state land office, does it?
I do not believe so.
Thank you. Turning to risk, which is the factor B, does your testimony doesn't address the fact that Rockwood has never drilled a well in New Mexico, does it?
My testimony does not contemplate that, but the plan is not for Rockwood to drill the well. If they receive a pooling order to operate the well, they're going to transfer it over to Mewburn.
Thank you for
like I
continuing
said,
to
has
make
drilled
my
the
point.
most wells in the area.
Thank you. Did you know that Rockwood is not a bonded operator?
I did not know that, no.
Did you know, so does your testimony, it doesn't address the uncertainty about who may be on the hook from OCD's perspective if anything goes wrong with your contract with with Rockwood, does it?
And I again want to object to this line of questioning. It appears that Ms. Bennett's getting into bonding questions, which are oversight related to the OCD. Any bonds that would be required to be in place would only come into play once those C-102s are filed. And so at this point in time, there's no bonding violation because there's no wells that have been drilled. You only have to have you only have to have bonds if you have wells. And at this point in time, Ms. Bennett is making her case very clearly that Rockwood has never drilled any wells, which is why they had to bring in a contract operator. And so just to be clear, I don't think that there's any technical or otherwise violation of the OCD rules because Rockwood does not have any wells drilled and would not be required to have any bonds. The bonding requirement correlates to the well number.
So the basis for the objection is what?
There's no relevance to any objection regarding bonding.
No relevance, Ms. Bennett?
Thank you. An operator's ability to have a bond and its actual bonding does go to risk. If there's no bond, to me, that is a risk that the OCD should consider.
But Ms. Luck and the witness have both stated that it's Mewburn that would be drilling the wells. And are you asking if Mewburn has a bond?
No.
Right, because that should be the question.
Thank you, Ms. Luck. Please don't help me. So, Ms. Bennett, I agree that this question is not relevant.
Thank you. I wanted to now turn to the tract maps that are part of your declaration. And so I am looking at page 39 of your declaration. Do you see that?
Is that for the 521H?
That is for the 521H.
Okay.
And so earlier today, you testified that at the end of each tract map, there's a unit recap, right?
Yes, ma'am.
And this is the recap for the 521H. Do you see that?
Yes, ma'am.
And Coterra has the majority interest in this tract, in this unit. Is that correct?
Yes, ma'am.
And then turning to the 523H recap, Coterra Energy majority interest. Is that correct?
Yes, ma'am. I don't think we're disputing the working interest. I think we're involved to protect Rockwood's interest because they have an expiring lease. So I don't think we're disputing that Coterra has the most working interest. I think we're just trying to make sure that Rockwood's interest is protected and that a well is drilled timely so that Rockwood and all these other owners don't have leases that expire.
Who are the other owners?
Charbrough Energy LLC has an interest. Salt Fork Limited has an interest. SR Primo Holdings has an interest. Guns Up Exploration has an interest. Marshall and Winston has an interest, and Worrell Investment Corporation has an interest.
Are Sharbo, Salt Creek or Salt, I'm sorry, I didn't catch the name. Let me start with Sharbo. Is Sharbo committed to the Rockwood JOA?
They have not signed a JOA, but they signed a letter of support supporting Rockwood's development.
Is that letter of support in the record?
No, ma'am. I believe Caitlin has it.
How about, what was the salt? So first of all, let me just take a big step back. Are any of those names that you just read, and I'm looking right now at the unit recap for the 523H well, just because that happens to be the one that my screen has landed on. Are any of those folks that you just mentioned, are they owners in the 523H well?
Yes, they are. They're included in Rockwood Energy LP's interest. We're not pooling those owners, so we did not list them.
So again, you did not list the committed working interest owners.
They wrote a letter of support, so we did not list them as a party we needed to pool.
And I'm not asking you if you listed them as a party that needs to be pooled. I'm asking if you included an accurate recap of who owns in this case, the east half, west half of the sections. Is this an accurate recap of the working interest owners in that section?
It does not include those owners. Those
Thank you.
owners have stated they would sign a JOA in favor of Rockwood Energy.
Thank you, but they have not yet signed it,
They have not. They wrote a letter of support.
and it's not in the record?
And
I
again, I
don't
would like to
believe so.
mention that we've moved to admit Exhibit C5.
Let's look at the tract map for the 526H well, which I have here on my screen. Are you seeing that?
Yes, ma'am. Let me pull it up on my end. Okay, I've got it.
So my understanding is that Rockwood seeks to drill a well from the north half of section 25 through section 36 and section 1, with ending in the south half of section 1. Is that right?
Yes, ma'am.
How much working interest does Rockwood have in tract 1 here that's depicted on this section plat?
Tract 1 in section 25, I don't believe they have any interest.
How about tract 2?
I don't believe they have any interest.
How about tract 3?
Tract 3, section 1, they have 100% of that tract.
I'm sorry, tract 3 is in section 36.
Oh, I'm sorry. Tract 3, they do not have any interest in section 30, in that part of section 36, I don't believe.
So in other words, Rockwood's plan is to drill through 2 full sections where they have no interest at all?
And
Correct.
Mr. Hearing Examiner, the point's been made here. All of this information is on the exhibit as to who each owner is in the tracts. And I think that Ms. Bennett's kind of belaboring a point here. There's one factor we're talking about, who has a majority interest ownership, and no one's disputing that's Coterra here. We're all in agreement regarding who has the majority interest ownership in this case, as well as the 3 others. And so I think that we've all gotten Ms. Bennett's point that Coterra has the majority interest ownership, Rockwood has the minority. We're talking about the other 4 factors here today.
So was that an objection?
Yes, this question has been asked and answered. Ms. Bennett has gone through this several times to ask whether Coterra has a majority interest in each one of these cases already previously.
Asked and answered?
Mr. Examiner, I have asked whether Coterra has the majority interest, but I also believe that it's important for the division to understand the scope of Coterra's interest and the fact that Rockwood is seeking to develop acreage that is 100% controlled by Coterra.
But the,
Can you bring that out through your own witnesses?
right.
Yes. Mhm.
Okay,
Thank you.
so I'm sustaining the objection. Is there more cross-examination?
Yes.
Okay, right ahead.
I'd like to turn now to the application that were the applications that were submitted. Did you oversee the preparation of these applications?
Yes, ma'am.
So again, they have the incorrect O-grid for Rockwood. Were you aware of that when you oversaw the preparation of these exhibits? I'm sorry, applications.
The plan was to transfer the orders over to Mewburn, so we probably didn't pay too much attention to that OGRID number.
And
Since the
Mr.
plan was to
Examiner,
transfer the orders over to Mewburn so that Mewburn can go protect the interest.
Mr. Hearing Examiner, I don't see the relevance of the OGRD number to this case in the proceeding overall. If this is a clerical error, we're happy to rectify it. Of course, we can't amend the applications at this point in time, but it is our understanding that Rockwood's OGRD number was incorrect on the applications, and we're happy to rectify it throughout the rest of the proceedings.
So what's the objection?
This issue has been covered previously by Ms. Bennett.
Okay, so Ms. Luck, if you could, being a former trial attorney, Ms. Luck, if you make an objection, please make it timely before the witness answers the question. And second of all, just say objection and then provide the foundation for the objection and let me deal with it. So, Ms. Bennett, the objection, well, you know what, Ms. Luck, the witness already gave the answer to this one, so this wasn't a timely objection. So we're going to leave that alone. So please continue, Ms. Bennett.
Thank you. Mr. Jolly, are you familiar with the division's material deficiency policy?
I guess not. What's the material deficiency policy?
It's a notice that was sent out effective June 11th, 2020. Do you see that on the screen?
Yes, ma'am.
And it states that the Engineering Bureau gives notice that it intends to deny applications for which the applicant proposes a material change. And I'm paraphrasing here, that's found throughout the administrative or technical review process. And if I turn to OCD hearing applications, it has two material deficiencies. One is change of the operator name and one is change in the operator OGRID number. Do you see those?
Yes, ma'am.
And again, I want to object to this line of questioning because this witness has stated he's not familiar with this policy. He has not seen it before.
Objection, Ms. Luck. Just say objection and basis. What is the basis?
Foundation.
Foundation. Ms. Bennett.
Thank you. I'm happy to move on. Well, I'm sorry. He did say that he's not familiar with the material deficiency policy. I also think it's relatively straightforward what I'm showing on the screen, that a change in operator name and a change in operator OGRID are material deficiencies.
Would this be better brought up maybe in a closing argument or something of that nature?
Certainly.
I mean,
Yes.
At this point, you're cross-examining this witness. He's not familiar with it. The objection was raised to foundation. I sustain the objection, but maybe you want to argue that on closing.
I didn't realize you'd sustained the objection. I apologize.
Well, I didn't. I was waiting for your response. Then you withdrew the question. Then you started arguing. So I was waiting for you to finish.
Thank you.
But I agree with Ms. Luck that he doesn't have knowledge of it.
Thank you. Mr. Jolly, you testified that you prepared your declaration, right?
Prepared the declaration.
Yes.
What are you saying the declaration is? I'm sorry.
I'm sorry, your self-affirmed statement.
Yes, ma'am.
Okay. So in paragraph 11, do you see where I have that up?
Yes, ma'am.
And in your declaration, self-affirmed statement, you said the costs reflected in the AFEs are consistent with what Rockwood has incurred for drilling similar horizontal wells, and you said and other operators, but I just want to focus on the Rockwood portion. You say the costs reflected in the AFEs are consistent with what Rockwood has incurred. But Rockwood hasn't drilled a well in New Mexico, has it?
Correct.
Do you see paragraph 12 here of your declaration?
Yes, ma'am.
And it identifies a chronology of contacts.
Yes, ma'am.
And in this paragraph, it says Mewburn has made a good faith effort to locate and has had communications with all the parties that it seeks to pool in this case. Is Mewburn seeking to pool anyone in this case?
No, ma'am. That must have been a typo. That need to say Rockwood.
And I want to clarify, I think that that sentence can be read a lot of different ways. I think that in,
Objection?
yes,
The objection.
I think that there may be some form misunderstanding there that in terms of how Ms. Bennett's reading that question, or sorry, that
What's the
statement.
objection?
Form.
Form of question. Okay.
Yes.
Ms. Bennett?
She was leading the witness.
Well, in cross-examination, what do you mean leading the witness?
Mr. Hearing Examiner, she read the sentence a certain way and wanted to make it seem like Mewburn is the it in the second part of the sentence. It could be Mewburn has made a good faith effort to locate and have communications with all the parties that Rockwood seeks to pull, because I'm not exactly sure how Mr. Jolly meant this sentence when he wrote it. There could be some misunderstanding. That's what I meant by form. I just want to be sure that this isn't being taken out of context. And as Mr. Jolly stated, maybe that's a typographical error, that Mewburn is not making a representation that it's pulling anyone in these proceedings. Mewburn is simply testifying for Rockwood in this case.
Objection is overruled. Did the witness answer your question?
He did.
I thought so. So please move on.
Thank you. I'm looking now at paragraph 13 of your declaration. And you said, and this is the second sentence where it starts most importantly, Coterra has not provided proper or timely mailed notice of its applications. Do you see that? It's right here. I don't know if you can see the mouse hovering over. Coterra has not properly or timely
Yes, I see
proposed the
that.
wells. Yeah, and not properly or timely mailed notice of applications. What's your basis for saying that Coterra has not properly or timely mailed notice of the applications in these cases?
I think the well proposals were sent out July 25th. Whenever I was preparing this affidavit, I believe you have to have 20 days notice. So if the case was heard today, we didn't think that met the notice requirements.
And I'm not talking about the well proposals. I'm only asking you about notice of the hearing applications.
And I want to object because the statement relates to both. It says Coterra has not properly proposed the wells or provided notice of the applications. And so I think that, again, Ms. Bennett's kind of taking this statement out of context.
So what's the objection?
Form.
Why don't you say that? I mean, I've asked you like 5 times, Ms. Luck, and when you make an objection, tell me the basis right off the bat. Because you're testifying.
Thank you, Mr. Hearing Examiner.
Ms. Bennett, just continue your question, please. Overruled. So Mr. Jolly, would you answer the question, please?
Can you repeat the question, please? I'm sorry.
Yes. What is your basis for the statement in your declaration that Coterra has not properly or timely mailed notice of the applications in these cases?
Well, just looking at the well proposals, they were sent July 25th. And I think that we were under the impression that the cases were going to be heard today. And so we didn't believe it was adequate time to notice all the owners they were pooling.
Thank you. Now that you know that the hearing's tomorrow, would you want to rephrase that statement in your declaration?
I'd have to get a date calculator out and see. I know it's pretty close to 20 days. I don't know if it actually is. I think the examiner said that he was going to hear the cases anyway, so.
You say in the same paragraph that Coterra has unduly delayed Rockwood's attempts to reach a voluntary agreement or drill the wells proposed in Rockwood's applications. Do you see that?
Yes, ma'am.
I want to talk about Rockwood's plans to drill the wells proposed in Rockwood's applications. When did Rockwood acquire this acreage?
I believe it was fall of 2024.
To your knowledge, did Rockwood undertake any plans to develop this acreage between the fall of 2024 and January 2025?
I have to look and see what the date of the well proposal is. It's like the well proposals are dated February 12th of 2025. So that's when they sent the letters out to try to get their acreage developed.
So that's your first understanding of an attempt that they undertook to get the acreage developed was February 2025?
I'm not sure if they reached out to Coterra in the fall of 2024. They may have, I'm not sure.
But you're here testifying, so to your knowledge, it was February 2025.
Yes, ma'am.
Do you know what actions Rockwood took in February 2025 to develop this acreage?
They sent out well proposals.
Do you know if they worked with the State Land Office on any surface locations?
I don't have knowledge of that.
Do you know if they undertook any surveys?
I don't have knowledge of that either.
Do you know if they have a rig in New Mexico?
I don't think they have a rig in New Mexico, no.
Do you know if they submitted APDs?
I don't know if they submitted APDs or not.
And how about in March? Do you know if Rockwood undertook any of those actions in March?
I do not know if they filed application. I don't think getting permits to drill is a big situation here since you're cutting through state lands. You can get those pretty quick.
That very well may be, but I'm asking if Rockwood undertook any efforts in March that you know of to develop its acreage.
I don't know if they did or not.
How about April?
In March. I don't know if they did in April either. I don't think you can, I don't think they could file the, I don't think they could file the permits across Coterra's acreage because it's a trespass.
Do you think
So they would have to,
I'm sorry, go ahead.
well, like you said, Coterra has a lot of interest here and they own some tracts 100%. So I think it's a trespass to file permits across someone else's acreage.
Do you think Mr. Powell could answer the questions that I just asked you?
He may be able to. You'd have to ask him. I'm not sure.
Let's see. Did you have a deal negotiated with Rockwood back in April?
I'm sorry, can you repeat the question?
Sure. Did you have a deal negotiated with Rockwood in April?
Yes, we had been in talks with Rockwood before that about this acreage, yes.
What happened with that deal? Did it fall through in May?
No. We negotiated a deal and no, I don't think anything fell through in May.
Did you tell Coterra that your deal with Rockwood had fallen through?
And Mr. Hearing Examiner, I'm going to object at this point in time. I believe that Ms. Bennett is going into the contract negotiations, which I mentioned in my opening statement, I think are an issue under Rule 11408. I think that any of the discussions that the parties had during pre-hearing contractual negotiations are not admissible during this hearing today.
So, Ms. Luck, as you said before, the rules of evidence don't apply in the administrative forum. But I don't see how this is relevant. So can you tell me, Ms. Bennett, why this is relevant?
Yes, it goes to good faith to Rockwood's argument that Coterra has not engaged in good faith negotiations. As I mentioned.
Okay, all right.
Thank you.
Thank you, Ms. Bennett. So, Ms. Luck, it is relevant line of questioning, but please keep it.
And Mr.
A few
Hastings,
questions is all we need here. Ms. Bennett.
if I may respond, good faith negotiations as interpreted by the division is what we're talking about here, which has been interpreted to mean a well proposal letter. And that's why we return to the chronology of contacts and we return to the exhibits that have already been filed before the division.
You can bring that out on redirect if you like, Ms. Luck.
Well, but I believe that what Ms. Bennett is trying to go into now is still impermissible. It's not necessary to bring up anything beyond what's considered by the division's definition of good faith negotiations.
Is that defined somewhere that you know of?
Yes, Mr. Hearing Examiner, that's defined in,
Enlighten me, please.
there's many pooling orders that define and describe what good faith negotiations are by operators seeking to pool units.
You tell me what it is.
A well proposal letter, one follow-up communication after that. All of this additional discussion that Ms. Bennett's getting into is not relevant.
Okay, Ms. Bennett?
Thank you. If that is the limited nature that Rockwood wants to take in terms of good faith negotiations, then I will hold their witnesses to that same standard. I disagree with her interpretation entirely of what constitutes good faith negotiations. We would not need to have a summary of communications if the division only cared about one proposal letter and one follow-up. That certainly is not the standard, but if Ms. Luck is willing to live by that standard, then happy to do so.
And Mr. Hearing Examiner, if I may respond, that's been the standard that's been applied with countless exhibits that Ms. Bennett has presented in cases regarding chronology of contacts with uncommitted working interest owners in cases like this.
I'm not sure that we need to go on about this subject. Ms. Bennett, it is a factor, so it's relevant. But I'd really, I admonish you to really keep this a tight subject for cross-examination.
Thank you.
Was there a question that hasn't been answered yet?
Yes.
What was the question?
The question was, did you tell Coterra that the deal with Rockwood had fallen through?
So to get into nitty gritty about who told what and when they told it, I think is beyond the scope of this hearing. Let's keep it to, more generalities of good faith negotiation.
Thank you. I'm actually going to move on to a different topic.
Okay, good. Thank you.
And Mr. Hearing Examiner, I do have the citation for the good faith negotiations if you'd like that. Sorry, I just had to find it really quick.
Okay, what is it?
Apologies. I just want to bring this up because Ms. Bennett did bring up her order earlier. This is order R 13165.
What does it say?
Because past division practice has not been entirely consistent and because some language of order number R 13155 was not intended to apply to all cases, the division takes the opportunity to clarify the requirements that will ordinarily apply in compulsory pooling cases as follows. At least 30 days prior to filing a compulsory pooling application, in the absence of extenuating circumstances, an applicant should send to locatable parties it intends to ask the division to pool a well proposal letter identifying the proposed depth and location and target formation together with the proposed AFE for the well. The proposal should specify the footages from section lines of the intended location and, in the case of a directional well, of the intended point of penetration and bottom of hole location.
Ms. Love, can you just confine your recitation of this rule to the part that goes with good faith negotiations?
This is it because it involves the well proposal letter, the details that should be included in the well proposal letter and the AFE, including the footage locations. The division understands these requirements to be comparable to the proposal requirements included in form operating agreements generally used in the industry. And then it goes on. There's 4 factors with regards to what needs to be included in good faith negotiations. I'm happy to submit this order to the division.
Oh, thank you. Ms. Bennett, do you take issue with any of this or do you know this already?
I knew that already.
Okay,
That is the order that governs good faith negotiations, but it does not, it has been the division's practice to inquire further into the parties' negotiations, especially in contested hearings, to understand the limits of or the extent of seeking voluntary joinder before we came before the division.
Okay. Well, you said that you were going to.
I'm moving on.
From
Yes.
this anyway.
Yes.
So please go ahead.
Thank you.
Thank you, Ms. Love.
Mr. Jolly, do you see I'm still focused here on paragraph 13 of your declaration. Do you see that?
Yes, ma'am.
And at the end, you talk about the applicable lease expirations. Do you see that?
Yes, ma'am.
What are the Rockwood leases?
There is a tract in the north half southwest quarter of section 36 that has an expiration July 31st of 2026.
Is that anywhere in your materials?
The date of the lease?
Yes, the date of the lease.
No, I don't believe so.
Then the next thing I wanted to talk about is, have you had discussions with, oh, sorry, one quick follow-up question. When did you finalize the deal with Rockwood?
I don't remember the exact date. We had been talking about that for a long time. So I don't know the exact date when the deal was finalized.
Was it around June 13th, 2025?
We had ongoing discussions long before then. I don't know the exact date of when the deal was finalized.
Would you say it was in June 2025? I know you don't know the exact date, but I'm just trying to understand when it could have been.
No, we had been in discussions long before then, so no, I would not say that.
So you don't know when it was finalized?
Correct.
Okay. Have you had discussions with Marshall and Winston about their interests in this acreage?
Yes.
Did you know that Marshall and Winston filed a motion to continue these cases?
Yes.
Did you discuss that motion to continue with Marshall and Winston?
Marshall and Winston reached out to us about the hearing. They've talked to us about the hearing. Yes.
About continuing the hearing?
Yes, we've talked about the circumstances surrounding the hearing with Marshall and Winston.
And is continuing the hearing consistent for a whole month or more consistent with your stated intent of getting an order so that you can drill these wells?
I guess it depends on how long it takes to get an order and which situation. I think we, in a good faith effort, contemplated continuing the hearing so that we could continue to talk with Coterra about this acreage.
Do you recall Coterra asking several times to have a continuance for these cases?
And Mr. Hearing Examiner, I want to object to this line of questioning.
Based on what?
Relevance, Mr. Hearing Examiner. We all discussed a continuance prior to this proceeding. Ms. Bennett is revisiting that now. She also mentioned at the beginning of this hearing that a contested hearing might not be the quickest way to get a pulling order. So it would be reasonable for all the parties to try to continue engage in discussions rather than go to a contested pulling hearing. It was a reasonable thing to discuss at that point in time.
So what's the objection? So what's the objection for her asking this witness that question? It's relevance?
Yes.
Okay, and Ms. Bennett, the objection is relevance.
Thank you. It's relevant to Mr. Jolly's statements that Rockwood and Mewburn intend to develop this acreage as quickly as possible to save the leases from expiration. And so I was just trying to understand the timing of a continuance and how that impacts his testimony with respect to wanting these cases to move forward.
And I think that we all understand that the division docketing.
Look, I didn't invite additional comment. I'm thinking, okay, so let me deal with the objection as it's been raised. Miss Bennett, it seems to me that there could be different reasons why a party may think that negotiations based on a continuance might be a quicker way to resolve an issue than, let's say, going to a contested hearing and then having the division, figure out who's the better operator. So there's different answers here. Did this witness give you an answer yet?
No.
You can ask the question and we're going to live with the answer that he gives, knowing that there could be different reasons behind it. So I think Ms. Luck makes a good point, but I will allow this witness to answer that question. So Mr. Jolly, please answer the question.
Can you repeat the question, please?
I'll do my best. My question was that whether, actually, my question that was objected to was whether you were aware that Coterra had asked for the parties to agree to a continuance and that the other parties said no, that we had to go to hearing today to save the lease expirations.
Yes, I think all parties have contemplated at one point or another whether the hearing should happen today or whether we should kick the hearing another month to see if we can try to work something out.
Earlier today, I believe Ms. Lux stated that, or maybe it was you, I can't quite recall, and I'm not sure from my notes, but that Coterra has known all along that Mewburn would be the operator of this acreage. Do you recall that?
I don't think I said that.
Do you recall Ms. Lux saying that?
Ms. Bennett, if he says he doesn't remember saying that, then it would be outside the scope of,
Okay.
of his testimony. So let's move on.
May I ask a follow-up
Yes,
question?
of course.
When was the first time that you know of, within your knowledge, that it was relayed to Coterra that Mewburn would be the operator of these wells?
I don't recall when they were notified for the first time. You'd have to ask them.
But it would be you that was notifying them, right, Mewburn?
Rockwood could have told him to. I don't know. Like I said, a lot of discussion was happening over the phone, so I don't know when the first time they heard that was.
All I'm asking is when the first time Mewburn told Coterra that Mewburn would be operating these wells.
We've been talking about this for several months. I don't know when we had that discussion.
Is there anything you can look at that would refresh your memory about when that discussion happened?
I don't think so.
Do you think that Mr. Powell would know when he first had a discussion with Coterra about this?
And I'm going to object on this one because there's no foundation.
Sustained.
Thank you. I just want to take a quick look at my notes and see if I have any other questions.
And then, Mr. Bruce, I'm going to ask you if you have any questions for this witness.
No further questions. Thank you.
Thank you, Mr. Bruce.
Maybe one or two.
Did you enter your appearance? I don't remember you saying something. It's been a while. Did you enter an appearance?
Yeah.
Okay, good. Go ahead, Mr. Bruce.
Mr. Jolly, I've heard talk today, is one of the concerns of Rockwood and Marshall and Winston that Coterra may not drill the wells in a timely fashion.
That's the main concern, yes.
And regarding the continuance that I filed on Marshall and Winston's behalf, and you discussed that these matters with Marshall and Winston, did you not?
Yes.
Was one of the reasons for the proposed continuance that Marshall and Winston had received the proposal letter and the notice so late it would not be able to prepare for hearing?
Yes, I believe Marshall and Winston's concern is that they got a well proposal letter less than 20 days ago. And so they wanted time to evaluate the well proposal, especially because they own interest in an existing well, and one of the wells proposed by Coterra overlaps that well for 1.5 miles.
Okay. Thank you. That's all, Mr. Examiner.
Thank you, Mr. Bruce. Mr. Fordyce?
Yeah, I have one follow-up question. Mr. Jolly, I'm looking actually at page 108 of 116. And it seems like we've established that these exhibits don't contain a complete list of interest owners and perhaps parties that are Rockwood is seeking to pool in this application. And in this mailing list, and it's the same for each of the cases, it only indicates that the State Land Office and Coterra were sent notice of these proceedings. I'm trying to ascertain, since we don't have a complete list of interest owners and who's being pooled, has everyone that was required notice given notice? Because I only see State Land Office and Coterra.
Coterra is the only party that Rockwood seeks to pool. So the other owners were not listed and weren't notified. They were notified. They know the hearing is going on, but they weren't set a notification of pooling because they're not being pooled.
One other follow-up question, since the C-102s weren't admitted and we don't have surveys for those wells, the question is, has Rockwood done any work to identify surface locations, or are those proposed surface locations simply theoretical at this point?
I'd have to defer to the engineer on that question. I'm sorry.
Yeah, I don't think I have any further questions for this witness.
Thank you, Mr. Fordyce, but you've opened up a subject that I was concerned about, and now I need to hear from Ms. Luck and Ms. Bennett. Ms. Luck, is it your position that the rule 1915-412, let's look at the rule for a moment, because I'm confused about something here. I'm looking at the version that is held by the state archives, which I believe is the official version. It says here, notice requirement for specific adjudications, compulsory pooling and statutory unitization. A1A, applicant shall give notice to each owner of an interest in the mineral estate of any portion of the lands the applicant proposes to be pooled. That is evidenced by a written conveyance, either of record or known to the applicant at the time the applicant filed the application, and whose interest has not been voluntarily committed. Ms. Luck, are you saying you complied with that rule?
Yes, Mr. Hearing Examiner, and together with Exhibit C4, we have the first few letters of support from the so-called uncommitted working interest owners. And then we have additional letters of support that we would like to submit to the division that include all of the defined owners of an interest in the mineral estate of any portion of the lands the applicant proposes to be pooled. So even though those folks haven't signed an agreement, they have voluntarily committed their interest to this unit and the units proposed.
Bennett?
Thank you. As the division is aware, the division ordered me to complete notice in another case under similar circumstances where a client had determined not to pool certain parties and had not sent them notice of the hearing. And the division read that rule rather broadly to say that if a party is uncommitted, that notice is required even if you're not seeking to pool them. And I understand Ms. Luck's position that there's letters of support from each of these, but those letters of support, if they are similar to the ones that are in the record, were signed on July 18th, well after the notice that was required under the division's rules. I think if it depends on what the division determines to mean the word committed to mean. If it means committed to a JOA, then notice, in my opinion, was not proper. If the division determines the word committed in that rule means a letter of support, then notice was probably proper.
And if I may respond, Mr. Hearing Examiner, voluntary committed is not defined, and voluntarily committed is not ever been defined to mean a JOA or another kind of written agreement. Parties can voluntarily decide how to either lease their interest or farm out their interest or enter into a JOA before a pooling hearing, and that can be a voluntary commitment.
Well, my concern is holding a hearing without having provided proper notice, because that's a problem for the division. And it's our responsibility to make sure that the applicants comply with the rule. And notices is critical. It's one of the things that is critical to us. And I think Mr. Fordyce and I need to take a break after this witness is done and decide how we want to deal with the idea of voluntary commitment through a letter of support versus well, that's the evidence that we have in the record as of now. So I think, let's see, Mr. Fordyce has asked his questions. Mr. Bruce did. Ms. Luck, any redirect questions for this witness?
Yeah, I just have a couple of questions dealing with issues that she brought up.
Go right ahead.
So Mr. Jolly, do you know when Coterra purchased Franklin Mountain Energy?
I believe it was January of 2025.
Okay, so they are fairly new to this acreage, correct?
Yes, they just acquired it this year.
Okay. And is it your opinion in this case that Rockwood has engaged in good faith negotiations with the parties to be pooled?
Yes.
And has it been your experience previously that at OCD hearings that sometimes Form C-102s would be submitted and then the final C-102s would be filed later on?
Yes, ma'am.
Okay, and so that's commonplace practice to submit drafts and then file final C-102s at a later time.
Yes, ma'am.
Okay, and finally, with respect to the letters of support. So we do have letters of support from each of the other interest owners in these units who may have had a mineral interest in the estate of any of the portions of the lands to be pooled. Is that correct?
Yes, ma'am.
Okay, that's all the questions I have for this witness. Thank you.
All right, thank you. Is there any recross on those questions?
Yes.
Of course.
Yes.
Go ahead, Ms. Bennett.
Mr. Jolly, you testified that Coterra acquired this acreage from Franklin Mountain Energy in January of 2025, right?
They bought both Avant and Franklin Mountain. I believe it happened in January. They press released it January of 2025.
So that was like 6 months ago.
8 months ago.
Okay. And but earlier you testified that Rockwood's had this acreage since sometime in the fall of 2024. Is that right?
I believe that's the date of the term assignment they took.
Mr. Bruce asked, may I recross on thing? Mr. Bruce asked a question about Marshall and Winston's concerns that you discussed with them. Do you recall that testimony?
I remember him saying something, yes.
Do you recall testifying that you discussed Marshall and Winston's concerns?
Marshall and Winston's concerns were about the timing of the well proposal letter when they only got it a couple weeks ago. And they have interest in a well that the spacing unit of the existing well overlaps with a well that Coterra proposed to overlap that spacing unit with. So they were concerned about that.
Does Mewburn have any interests in that overlapping spacing unit?
No.
I believe you might have testified that Marshall and Winston wanted time to evaluate Coterra's proposals. Do you recall that?
Yes.
Marshall and Winston is committed to Rockwood though, right?
They support Rockwood's development.
Did you know that Marshall and Winston has signed a JOA?
With whom?
With Rockwood.
I wasn't aware that they signed a JOA.
So that's in your exhibits to your declaration.
I saw the letter of support. I knew that they would sign a JOA if they were asked to sign one. I didn't know it had actually been signed yet.
Did you review the support letters?
Yes, ma'am.
Do you know who prepared the letters of support?
They were prepared under the guidance of both Rockwood and Mewburn.
Okay, I'm going to represent to you, and I'm happy to pull up the letter. Let me just see if I have it here. From Marshall and Winston. Oh, that's the George Mitchell letter. Okay, sorry, I'm just
What page are you on?
I'm looking for that page number. I apologize. It's page 61 of 116.
Okay.
And
yes,
it's
ma'am.
Okay. And do you see that at the very end of that there's the first full paragraph and then there's a single sentence that starts Marshall and Winston has signed. Do you see that?
Yes, ma'am.
And that's dated July 18th, right?
Yes, ma'am.
And the wells, it says the wells are being proposed under an operating agreement dated July 15th, naming Rockwood Energy as operator.
And I'm going to object. I think that Ms. Bennett's made her point here. This question has been asked and answered.
What question has been asked?
Her line of questioning related to what this letter of support says.
What's the question that's been asked and answered?
She asked the final line says Marshall and Winston has signed Rockwood's proposed operating agreement and fully supports Rockwood's development plan in this area. And I believe she's already asked this multiple times whether or not Marshall and Winston has signed a JOA with Rockwood.
Ms. Bennett?
Thank you. What I was getting at with the second line of questioning is that the operating agreement is actually dated July 15th and names Rockwood as the operator.
Okay.
Which is information that is inconsistent with what is being presented today.
I see. So you're saying, okay, and the objection was that you've already asked and answered this. Now, have you already asked this question?
No, I had not asked a question about when the operating agreement was signed and who it named as operator.
Okay, all right. So Ms. Luck, that question hasn't been answered yet.
Okay, I'll withdraw my objection.
Thank you, Ms. Luck. So would the witness please answer the question?
What's the question? If the operating agreement has been signed, or why it says Rockwood Energy as operator?
The question is whether you were aware of the fact that Rockwood has signed a JOA with, that Marshall and Winston has signed a JOA with Rockwood as of July 15th, 2025.
The plan is for Rockwood to transfer ownership to Mewburn, so that's easily done in an operating agreement, so that shouldn't be an issue.
I appreciate your answer, but that's not the question I asked. I asked you if you were aware that Rockwood and Marshall and Winston have entered into an agreement dated July 15th, 2025.
I was aware that Marshall and Winston would sign what JOA we wanted them to sign. I wasn't aware they had already signed one.
And when you say whatever JOA you wanted them to sign, is that Mewburn?
If Rockwood obtains an order, then the deal is for Mewburn to step in and be an operator of the pooling order. So Mewburn would be operator and Marshall and Winston would support us.
Is there anything in the record that says Marshall and Winston supports Mewburn as operator of these wells?
No, they support Rockwood's development since they're pooling the wells.
Is there anything in the record that demonstrates that Rockwood has given you authority to testify on their behalf today?
And once again, I'm going to object to that. This has never been a requirement before the division. Ms. Bennett has had many clients testify before the division, and the contract terms
That's the objection.
relevance. The contract terms.
Thank you, Ms. Lund. Thank you, Ms. Bennett.
I withdraw.
Why are you?
I withdraw my question.
Thank you. I sustain the objection.
Has Mewburn entered an appearance in these cases?
No, not to my knowledge.
Thank you. Those are all the questions I have. Thank you.
Okay, Mr. Bruce, no, you're shaking your head. No, okay. Mr. Fordyce, any questions based on what Ms. Bennett has asked?
I have no further questions at this time, Mr. Hearing Examiner.
Thank you. Ms. Luck, is there any redirect on those questions?
I would just like to clarify with respect to Marshall and Winston.
With the witness?
Yes.
Go ahead.
Okay, so Mr. Jolly, Marshall and Winston is one of the interest owners that could be considered uncommitted in this unit. Was it not for that letter of support? Is that correct?
They have not signed, well, I guess they could be considered uncommitted, but they support Rockwood's development.
Mr.
So I
Hearing
think
Examiner, I'd like to object to this line of questions as asked and answered. I asked the evidence that Ms. Luck herself provided shows clearly that Marshall and Winston has signed a JOA. It's not merely a letter of support.
Wait. Were you, okay, so first of all, what's the objection?
Asked and answered by me.
Asked and answered, okay. So Ms. Luck, the objection is asked and answered.
Okay, well, the question has not been answered. I'm trying to clarify with Mr. Jolly because Mr. Fordyce did raise an issue that there may be a notice issue, and I want to just iron that out as much as possible before we move on, that no additional notice is required.
You had the opportunity to iron out the notice issue after Mr. Fordyce asked the question, and that was before, and I gave you an opportunity to redirect, and that wasn't dealt with then. Now you're only allowed to ask questions based on what Ms. Bennett specifically asked. So please confine your scope of your questions, your redirect to what Ms. Bennett asked.
Yes, Mr.